All rise, court is now in session. The Honorable Terrence R. Ketchel presiding.
Please be seated.
Excuse me, Judge Ketchel. Your Honor, as the court gets settled, may I approach?
because the court gave her that, this court gave her that opportunity. She simply not availed herself of that. She has a Christmas tree left at the home. She's had since May 26th to get her Christmas tree.
You're saying that's what you believe the only
That's what she told
property-
the judge in Liberty County. So I respectfully disagree, but I understand the state's position, but I respectfully disagree with that.
I mean, it cuts both ways. I recognize the, I recognize the position of both parties based on the severity of the charges, and that our primary goal is to make sure and protect the victims and make sure and keep them whole. I'm going to go ahead and grant the state's, I think it's a reasonable request, so I'm going to grant your request, but it's going to go into effect that the defendant can return to the home and obtain exclusive use and possession of the home starting at midnight on Wednesday. So Tuesday, she will have the opportunity, to go in and
She can go in.
obtain whatever her personal property is. The only thing I would add, because we deal with a lot of this is a criminal matter. I dealt with so many of these in the injunction arena. Just ask her, just take her stuff.
Keep it
That's all I would
civil,
ask
as we
her to
say.
do, because if not, it's going to just be more issues and more, accusations of, anyway.
And, Your Honor, we
I'm just-
will convey to her that this is basically, there is the court's deadline, and that anything that is there that is hers, she does need to have removed, and she will not be returning to the residence after that.
And
We'll make
I
that very
think
clear.
we should say that, she's, anything that's not there, that she's abandoning. In other
We will
words,
include that, yes.
I don't want her to leave something, say, well, I didn't, and then he gets rid of it, and then.
We'll make it very clear that the court has given her the additional time, and that will be the deadline. If it's yours, you take it. If not, then it's his to do with as he pleases.
Okay.
And then it becomes a civil matter.
Very good.
We will take care of that, Your
This is my
Honor.
first case.
And I appreciate you letting me go first. I will.
Anything
Your Honor,
else?
when you mentioned, just for clarification, midnight, does that mean she has all day Tuesday and at 12:01 Wednesday morning?
That's right.
That's
I'm
what
saying.
I-
I'm just
Okay.
I'm
making
just making
a
sure.
bright line
Yeah.
that
we
anything
want.
through until 11:59 on Tuesday, she can be at the home at 12:01 that Wednesday morning AM. I'm trying to have a bright line.
And Your Honor.
Hopefully, she won't be there at 11:59,
And Your Honor, what we will also do out of respect for the request is if we do find out from her, we'll ask her to tell us when she's complete. If we find out that it's completed prior to the deadline, then I will convey that to Mr. Flowers so he can let his client know. Or not. Just leave
I
it.
would say,
We'll
I
leave
would
it.
suggest not, because this is a written court order.
We'll leave it.
And we do something verbally, there's the potential, if she gets out 12 hours early or a day early, fine, just sits
Okay.
for a day.
We'll do that, Your Honor. I certainly understand. That makes sense. All right. But we will convey that to her and make sure that's,
Can she take pictures? Can she take pictures of what she takes so I can know?
Yep.
The one thing I would ask
Two things.
is that we paper this. So can you coordinate some
Yes.
kind of order so it's in the court file exactly?
We
And
will do that.
I've got notes of it here, but
And Your Honor, suggestion I'm going to make when we put this order together, the items that she comes to retrieve, that there's going to be an inventory made of those items.
that she
That
retrieved.
she retrieves when she comes back prior to Tuesday.
Or the prenup that I have.
I'm not going to get in the middle, this is not a property
I don't want
dispute, I'm not
to-
doing it. That's
Thank you,
not,
Judge.
that doesn't need to be in the order.
More than I want you to.
I understand the dispute, but I'm not going to have that in the order. I'm not
Understood.
getting, I'm trying to stay away from the property dispute. I actually went a little above and beyond by suggesting to the state that please pass on, don't take what's not yours. I get it. They've lived together maybe, they have difference of opinion what ownership is. That's not our primary responsibility here in the criminal
Your
arena.
Honor, I respect that order.
Okay,
And- and
good
we'll-
luck.
And we'll
Thank
draft
you.
something to that effect. Thank you.
thank you, Judge. All right.
Okay.
Your Honor, that's all I have. Thank you.
Okay, thank you. Have a nice day. Okay. One preliminary item that I just wanted to share, there are, this morning's docket contains a number of defendants, most of which are here on violations of probation, that have not had an attorney appointed. Essentially, today's hearing is like an arraignment with a new law charge, but this is a violation of probation. In other words, the purpose of today's hearing is to deny, admit, and possibly resolve these matters. However, if you have not had an attorney, you've not had a chance to interact, well, you may have, but more likely than not, you have not interacted with the state. And so I'm going to give you an opportunity to obtain an attorney if you cannot afford one, okay? I'll say this, in criminal matters, always strongly suggest you have an attorney. If you can't afford one, the court will appoint one, okay? So I'm gonna do that. I'll give you an opportunity, and I'll enter a denial. So that won't give up any of your rights. Very quickly, you can then meet with your attorney, figure out what to do about it. We'll come back on the next hearing and try and figure out how to resolve it, go to a hearing or whatever, okay? So I just wanted to let everybody know, when your name is called, please come forward as quickly as possible to the podium, and we'll be able to get through this fairly quickly. So I believe we got our first one on the doc, DeAndre, I think that was continued.
I believe, Your Honor, I spoke with Mr. Whitmer. He was here in the hall earlier. He had another matter. I told him I thought this was continued
It was.
already. I wasn't
That's
sure.
my notes.
We could just make sure we do actually have a date set. The recommendation from Mr. Whitmer was 60 days.
Okay.
I'm not sure if there's already a date.
You want to do it on another miscellaneous?
Yes, sir.
Okay. So, let's see, 60 days would be, we can either do it August 25th, or then it would go all the way to September 20th. September 8th is a hearings only. It's
Either
not-
one, Judge.
Either one. You want to do we have some on the 25th of August? Okay, so we'll do it in the morning on August 25th. Continue to August 25th. Okay, very good, thank you. Okay, Azaria Bell. Please come forward. Would the state go ahead and announce? Just come up to the podium, sir.
Your Honor, before the court is Azaria Bell on 22 CF 1472 and 21 CF 1112.
Okay, I didn't get the one. I only have it under one. What's the first one you said?
He's on the plea day docket.
He's on the plea day docket. Okay. Okay.
On 22 CF 1472, he is charged with possession of a controlled substance. He also has a violation of probation under 21 CF 11112.
So, Mr. Bell, as I mentioned to you before, you don't have an attorney in either one of these. Do you wish to have an attorney appointed, or are you going to hire private counsel? You want a public defender? Okay. So the courts, as I said, I'm going to appoint the public defender in both of these matters. In your new law charge, 1472, the court's going to enter a not guilty. And we'll come back on our August 22nd? Is our next cycle? August 22nd?
That's fine, Your Honor.
Okay. August 22nd for pretrial, and then the violation of probation. Do we want to run these together?
Yeah, that's fine.
Yes, please, Your Honor. That would be
Okay,
great.
so court's again going to enter a denial, and then we'll come back on August 22nd, 9 a.m.
Yeah, and so he's excused from this afternoon, I just want to make sure.
That is correct. You don't have to come
Okay.
back this afternoon. Yes, sir. Thank you. Irvin Bush. Irvin Bush.
Your Honor, Mr. Bush is is on supervision with us, and he's on GPS. I can locate him if you'll give me a minute.
Okay, we'll pass over it. Elijah Daniel. Would the state announce?
Yes, Your Honor, this is 19 CF 804. We're here on a violation of probation arraignment.
So again, Mr. Daniel, you do have first order of business, you do have right to an attorney. You wish to have an attorney appointed, you're going to hire private counsel.
This is, all I got is 2 classes left with my Bridgeway classes.
Okay. There's been a violation of probation
Yeah, I
that's
know.
been filed. You really need legal representation. If it's something minor, hopefully they can work it out. So
It's
you want to
minor.
have an attorney appointed? Yes.
Yeah.
Okay, court will appoint the public defender. I'm going to enter a denial, so you have a chance to meet with your attorney, kind of work this out, okay? We'll come back on, let's see,
Because my probation over.
come back on July 28th in the morning.
And Mr. Daniel, if you can pay off all of your court costs that's current,
Ordered stay in the hotels.
what day was that, Judge?
July 28th? In the morning. Without subpoena. Okay. Lamarcus Tatum. We have somebody from regional conflict. Let's pass over that. We'll do Abrams. Ms. Etheridge?
Yes, Your Honor. Casey Etheridge for Barbara Abrams, and we're here in 2022 CF 210 and 2022 CF 1432. She would like to withdraw.
Sorry, what's the other one? Is that,
Or which one?
you said 22-210, that's the only one I have. Is there another case?
22 CF 1432.
22 CF 1432. What are those charges?
And that's felony petty theft and resisting an officer without violence.
Okay.
Your Honor, she'd be withdrawing her plea of not guilty and entering a plea of no contest to all the charges in both cases and accepting the state's offer. And on 2022 CF 210, it would be 18 months of community control, cost supervision waived.
May I have some community
Hold
service
on.
work on that?
Hold
money
on,
item?
just hold on.
Okay.
Okay, successfully complete the Keaton program and any aftercare. Defendant will not be released until picked up by the Keaton program representative. No possession or consumption of alcohol or drugs without a prescription. Stay away from Pick and Save. Restitution to Pick and Save in the amount of $5.17. $415 in court costs, $100 cost of prosecution, $150 public defender fees. And count 2, adjudication of guilt, credit for time served. Count 3, adjudication of guilt, 18 months of community control, concurrent with count 1. And then in 22 CF 1432, it'd be adjudication of guilt, 18 months of community control, concurrent with 2022 CF 210, cost of supervision waived. Same terms and conditions, an additional $415 in court costs, $100 cost of prosecution, $150 public defender fees. And count 2 would be adjudication of guilt, credit for time served.
And can I get may I get the court cost done in community service work while I'm at Keaton?
State
Because
has
I
no
have to go
objection.
to work and volunteer anyway, so,
Okay. Okay.
thank you.
Would you like me to include
Stay
that
in
on here,
agree-
Your
yeah,
Honor?
put that
Yes,
in.
Your Honor, absolutely.
Thank you.
Okay, Ms. Abrams,
Yes, sir.
let me swear you in, just ask you a couple questions. Do you
Yes,
swear
sir.
or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, that was quite a mouthful that your attorney just said.
Yes, sir.
I had a hard time. She was laying it out there. It's a comprehensive plea agreement. I want to make sure that you understand it and
Yes,
you're in
sir.
agreement with it.
Yes, sir.
You did a good job explaining it, counsel. By
Yes, sir. I'm praying real hard for these.
Okay, so the core of this plea agreement, and there's on several of the charges, that are the three felony charges will be the 18 months of community control.
Yes, sir.
And as a condition of that community control, which is a higher level, higher level of probation, right? But
Yes, sir.
it'll be you participating and completing the Keaton program and any aftercare, okay?
Yes, sir.
That's the biggie here, okay? It's not easy, so this basically just the start. This ain't the end, right?
Right.
You're getting out of jail, everyone's happy, hey, I want to get out of jail.
No.
But this is just
my
the start
blessing.
for you, and we hope it's successful for you. But
It
it's
will be.
got to take a lot of effort on your part, you know that.
Yes, sir.
It's not easy. The other ones that are the non-felonies are shorter time periods. So you're just getting credit for time served. Those will be completed here today.
Yes,
Okay,
sir.
you get
Thank
credit
you.
for time served. If you already spent a little time in jail, that's what you'll deal with on that. But by doing this, you are waiving the right by entering this plea agreement. I'm sure you know this, but I want to explain it to you. You're waiving the right to go to a trial and contest all this stuff. You believe that's in your best interest?
Yes, sir.
And I see that you've signed the plea and sentencing agreement.
Yes, sir.
Did you go over all this in
Yes, sir. I
detail
have
with
a
your
cop-
attorney?
I have a copy at the jail, yes, sir.
Okay. And you've discussed it with your attorney, made
Yes,
sure you
sir.
had all your legal questions answered?
Yes, sir.
Okay.
I'm actually excited to get this part of my journey going.
Very good. Based upon your testimony, the court will accept your plea and sentencing you on 22 CF 210, count 1 and count 3, and 22 CF 1432, count 1. Those three will be an adjudication of guilt, 18 months of community control. These will run concurrent. They're not on top of one another. They're all running at the same time.
Thank you.
The other charges will all be an adjudication of guilt, credit for time served. There are some fees and costs that are outlined in this, and you have to pay those fees and costs while you're on probation. And you may complete the community service work that's called for in here while you're at Keaton.
Thank
Okay?
you, sir.
So, any questions?
No, sir.
Okay, good luck, ma'am.
Thank you, sir.
Yes, cost of supervision is waived?
Okay, but she is to remain in custody.
Yes,
in
thank you.
Keaton, and the community service work is at $10 an hour?
Yes, sir.
Okay.
Thank you very much. Albro? Ms. Glisson, would one of you all, would you call Regional Conflict, see if they're coming over here? I just want to make sure they're, as I see it, there's not, there might only be one this morning. Ah, okay, that's why they're not there. Don't worry about it. So, we'll call it next, so it'll get it. Okay, so Jennifer Albro.
Casey Etheridge for Jennifer Albro, and we're here in 2021 CF 2514. And Your Honor, we would ask to continue this. One second.
Hang on.
What?
All right, I've just
Okay.
wanted to make
Oh, I know, I'm
sure.
just letting you, yeah.
What does any of that mean?
email.
Okay,
Okay,
she won't consider community control
not today, not today. Okay, Your Honor, we would be asking to set this on, I guess, 7/28.
He told me that the misdemeanor will go on 17.
Very good. We'll continue to 7:28 at 9. Is that without subpoenas in the morning? In the
Yeah.
morning, without subpoenas?
Yes, Your Honor, please.
Okay.
Thank you.
7:28 without subpoenas in the morning. Did I see Ms. Gooden come in?
She was sitting, yeah, she was.
Do you have a case, do you have a case?
Yes, Your Honor, but
I don't have-
of the hearing, we were gonna go last.
You don't have to wait and go last. If you only have one hearing, what do you got? It's not that you're getting priority, it's just that you only have one. If Ms. Etheridge only had one, I'd let her go first, too.
Yes, Your Honor. We have
Who is this?
Eldon Garlow.
Garlow?
And Your Honor, this is the case that I asked if we could do like a pretrial conference
I
on.
thought that was in the afternoon, not this morning. Okay,
The state and I both had it on for
that's
this
fine. It's just
morning.
I hand wrote it in, so. Okay.
But due to the nature of the hearing and the testimony, we were gonna go last.
Okay, well, I don't disagree with that, so if you, let's
Thank
go ahead and
you.
let you go last.
Thank you.
Okay.
Your Honor, we have located Mr. Bush, and he is here.
Okay. Very good. Mr. Bush, you want to come forward, sir? Thank you, Mr. Berry.
Your Honor, Mr. Bush is before the court in 16 CF 2626. It's a violation of probation. The underlying basis for the VOP was a new law case, 22 CF 1363.
Is that on the plea, the arraignment docket this afternoon?
It is not, Your Honor.
That's all right.
It's actually showing open on benchmark. However, a no pros was filed by the state May 27th. Given that the new law violation was the sole basis for the VOP, we would ask the court to dismiss the VOP and reinstate Mr. Bush to original terms and conditions.
Okay, so you're withdrawing the violation of probation?
Yes, Your Honor.
You're not asking me to dismiss it, you're withdrawing it?
Yes.
Okay. So the states, so you understand that, Mr. Bush? Good news. They're withdrawing the violation of probation because it was based on a new law charge that they've dismissed that.
Yes, sir.
Okay, so you're back on, we're not even reinstating, you're still on probation?
Yes, sir.
So just stay in good contact with your probation officer like you've been doing?
Yes, sir.
And you're good? Where
Yes,
they're
sir.
withdrawing, the state's withdrawing this matter.
Okay,
Mr. Berry?
Thank you, sir.
And Your Honor, Mr. Bush is scheduled to terminate probation in October,
Okay,
and unfortunately, he hasn't been able to pay his court costs. Can we just go ahead and put that to collections at his termination date?
that would, the state, without objection from the state, the court will, okay. Without objection, the court will grant that.
Right, and his GPS fees will be waived at that time also.
Yes.
Okay, thank you.
And just to clarify for the clerk, if they could close 22 CF 1363, please. Okay. I just saw it on benchmark. It was open this morning. Thank you.
Now, let's go ahead and dispose of Tatum. I understand that was the one that the regional conflict, I think,
Who was it, Judge?
there was going to be a
Lamarcus
agreed
Tatum?
upon, yeah, Lamarcus Tatum, yes. 21 CF 2382. The clerk indicated that there had been a motion for a continuance, or
Okay.
are you all in agreement on that?
Yes, Your Honor, no objection.
Okay. So we'll continue to July 28th in the morning. Without subpoenas. Okay. Continuing on, Ms. Etheridge, John Beagles.
C. Etheridge for Mr. Biggles. He is approaching. And Your Honor, there was an evaluation done in this case. and Mr. Beagles was found not competent to proceed. This is 2021 CF 2135. The state is asking for a second evaluation.
Yes, Your Honor, we are asking that Dr. Zeman be appointed and to conduct a second evaluation in this matter.
Very good. The court will grant the state's request for a second evaluation. How long out do you think before, probably maybe, should we do 60 days rather than August 25th rather than
Yes, Your
July
Honor.
28th?
Yes, Your Honor, absolutely.
Okay, so we'll come back here, we'll continue this until August 25th to get
You got it?
the evaluation time to get done, okay?
Thank you, sir, very much.
Thank you.
See you then, August 25th. Yes, sir.
Beatler,
Here this way,
We're
sir,
good.
you're good.
we're good.
You can go this way, sir.
You can come this way. You're good, that's all we
You got a
need.
little
Just stay in
turn.
touch with your attorney, okay? Yes, sir. Okay, thank you. Wesley Beatler.
Casey Etheridge for Mr. Butler, and we're here in 2021 CF 229 and 2022 CF 1413. If I could just have 1 second, Your Honor. Okay. He would like to accept, he'd like to admit to the allegations in the affidavit, yes, and accept the state's offer of adjudication withheld, revoke, and terminate, 12 months of community control, followed by 12 months of probation, cost supervision waived, $100 cost of prosecution, $150 public defender fees. That's in 2021 CF 229 that has a violation of probation case. And 2022 CF 1413, it'd be adjudication withheld, 12 months of community control, followed by 12 months of probation, cost of supervision waived, $515 in court costs, $100 cost of prosecution, $150 public defender fees, substance abuse evaluation, any recommended treatment, no possession or consumption of alcohol or controlled substances without a prescription.
Agent agreement.
Yes, Your Honor.
Score sheet.
Is that the right angle?
That's an agreement as to score sheet.
Yes, Your Honor, no objection.
How do you pronounce your last name, sir?
Beitler.
Beitler. Mr. Beitler, would you raise your right hand? Do you swear or affirm? Thank you. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, so the 1413 is the new law charge, correct? That's not on, actually
Yes,
not
Your
on the
Honor.
docket, but
Yes, Your Honor.
we'll deal with all of them at one time. So,
Apologize.
Mr. Beitler, you heard your attorney state the terms of the plea agreement.
Yes, sir.
And was that an accurate rendition? Is that what you understand? I see you signed the plea and sentencing agreement that contains these as well as a bunch of other information. Did you go over this plea and sentencing agreement with your attorney to make sure you understand all the legal ramifications?
Yes, sir.
Okay. You understand that by entering this, you're waiving the right, actually a number of rights. You're waiving the right to go to a trial, right to confront witnesses, the right to have the state prove their case beyond a reasonable, all those things. In other words, it's basically you're resolving all those and waiving those valuable rights. You understand you're doing that? Okay. Why are you entering into this agreement?
Between me and my girlfriend, we have 4 kids and really need to be at home
attending the things opposed to being where I'm at.
Okay, so we're going to revoke and terminate supervision on the current case. There'll be, on both cases, there'll be 12 months of community control followed by 12 months of probation, okay? You've had it explained to you about community control, higher levels, basically house arrest. Got to coordinate very closely on that, you end up back here. A lot of people have problems with that community control. Are you willing to do that? Don't want you to agree to this now so you can get out of jail and then end up
Right back.
getting in worse shape when you come back in a violation. I just want to make sure you understand and you're committed to following through on this so you can be successful.
I believe I have the motivation I need.
Okay. Very good. There are also a number of court costs and fees that have to be paid while you're on probation. So do you have any additional questions, either of your attorney or of the court at this time?
So it'll be 12 months CC and 12 months of probation altogether.
That is correct. Those will be, they're on both of them, and they're run, it's
Concurrent.
called concurrent, so they're not being stacked. They're running at the same time. So you're right, the total 12 months community control followed by 12 months of probation for each of them, but they'll all be done at one time. Okay, very good. Based upon that, the court will accept your plea and sentence you to the 12 months of community control followed by 12 months of probation. As to both cases, they will be handled concurrently. Cost and fees will be paid during the course of the probation. There's some other evaluation, substance abuse, very important, follow through with that, okay, sooner than later, okay? Very good. Thank you very much. Good luck. Vince is okay with the score sheet?
Yes, Your Honor, no objection.
Preston Beverly.
CF Ridgeford, Preston Beverly, and we're here in 2020 CF 2105 and 2021 CF 73. And Your Honor, we would be asking to continue this to 7/28, so I can talk to Mr. Beverly in this case.
State.
No objection, Your Honor. Thank you.
Okay. So when we come back in 7/28, we'll
Be on
either
the morning
resolve
docket.
this or go to
Yes,
trial?
correct.
Okay, so we'll put last. Ryan Bielik, your excuse, sir. Thank you. Sir. Stay in touch with your attorney, okay? We don't have to.
I think he's out of custody, I believe. I did not see him, and I've announced his name a couple times. I have no legal objection to whatever the court would like to do. I don't know if he has a case set for this afternoon off the top of my head, but
I believe
If
that-
he's on supervision, I will try to contact him. If he's not on supervision with me, I'll try to contact his probation officer to see if they can round him up.
I'm going to go ahead and issue a capias at this point with no contact, but if you want to try and get him here, we'd probably, might save himself.
would that be a KBS no bond, Your Honor?
I'm sorry?
Would that
Yes.
be a no bond? Okay, thank you.
Michael Blasberg, he is incarcerated. Blasberg?
He was handled yesterday, Your Honor.
Oh, he was? Okay. Great, thank you. John Bonow? What do you think? Is that Bonow? I'm sorry? Yes, thank you.
Your Honor, Mr. Bonow is the one that, Your Honor, released on ROR bond because he needed emergency surgery, and the jail asked to give him an emergency bond.
Yes, and I
When was
actually
that?
waived
When
his
was that?
appearance because I believe he's still in the hospital.
That was last week.
Yeah,
Okay.
So if we could just get
Okay,
him.
let's continue it to 7:28
thank you.
in the morning.
Yes,
Yes, please.
please.
Hold a second. Let's- Should we continue it or enter a,
Enter a plea of not guilty for today, Your Honor, and.
we'll enter not guilty, because you've already been appointed, so that's good.
Yeah.
And we'll come, do you want to run both of these to,
Can we put them both on
pre-trial on
seven?
August 22nd?
that's
Or
fine.
do you want to?
Yes, that would be better. That
That's
way it
fine.
gives them a chance to.
Okay, so we'll
Ew.
put both of them on August 22nd, pre-trial.
Thank you, Your Honor.
Okay, Anthony Bristol.
Bristol.
Bristol. Go ahead and announce.
Yes, Casey Etheridge for Anthony Bristol, and we're here in 2020 CF 1183. May I just have 1 second?
I have to.
Just one. If we could pass this case to 728.
Okay?
Oh, it is. Okay. Do we have that? I don't know if I.
Yes, the option is 6 months county jail or 12 months community control.
Okay, Your Honor, if we could pass him, I need to write an offer up that I don't have in the file for some reason.
Okay.
Thank you. I just gotta write it up. Yeah, I just gotta write it up. Yeah.
Jesse Coleman.
Etheridge for Jesse Coleman, and we're here for a motion to reduce bond. And this is in 2022 CF 594.
Okay. The defense may proceed, and then
Okay.
state can respond.
And Your Honor, I'd like to call Mr. Coleman.
Coleman, would you raise your right hand, Mr. Coleman? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
I just want to make sure, Mr. Coleman, by doing this, this is being recorded. You're waiving the right, you're waiving a Fifth Amendment right against self-incrimination by having this discussion here today, answering these questions. Do you understand that? Have you kind of had that discussion with your attorney?
Yes, sir.
So you're good with waiving, you're okay with waiving that right to not testify? You don't have to testify in a criminal proceeding.
Yes, sir.
That's based on our U.S. Constitution. It's actually in our Fifth Amendment. That's why they call it Fifth Amendment right against self-incrimination. It says you can't be compelled to testify against yourself. But you're voluntarily putting yourself out there. State may ask you some questions on cross that, just wanted to make sure you understand that there is some potential risk on this, and you've gone over it with your attorney that it's in your best interest.
And then I just have argument.
Okay,
He's decided not to speak.
okay. You may make your argument.
Your Honor, we're just asking for the court to lower the bond. In Mr. Coleman's case, he can't afford the amount. He's been in custody since,
What's the bond?
1 second,
The motion says it's 110,000.
110,000, yes, Your Honor, apologize.
You may. I'm sorry. I apologize.
Fine.
I was
You're
waiting
fine, I
for
was just
you.
making sure that you were, okay.
No, no, no.
And we would ask, Your Honor, that the bond be lowered to something that Mr. Coleman can afford.
What is the current amount of the bond? That's,
So it's $110,000.
okay.
He's been in custody since February 27th of 2022. There are depositions that are awaiting to be scheduled. This case was continued to August 24th. Mr. Coleman would like to be able to get back out and work and be out of custody while he's waiting for resolution of
What
this
is he
case.
requesting specifically?
Just 1 moment. So he's asking for a $5,000 bond on the possession. And then if we could do no. He would ask for a combined amount, Your Honor, of $5,500 cash or professional, or something close to that, Your Honor, if possible.
Is that all? I'm sorry. Is that all?
Yeah, that's it, yeah.
Your Honor, the state does acknowledge that this is a high bond. This is a very serious case. On February 27th, police were dispatched to JJ's bar regarding a male having a handgun out. And when they arrived, he still had his handgun out. He would not cooperate with police. He would not drop the firearm. He would not surrender to police. Instead, he ran off, firearm in hand, from police. They ended up having to get canines. They had to get drones. Mr. Coleman exhibited issues and concerns regarding the safety for the citizens of this county. He showed no concern regarding their safety. We have to, as citizens of this county, be concerned for our safety, and the state attorney's office is concerned that if the court were to reduce his bond to $5,500, that their safety once again becomes an issue. We would ask that if the court considers modifying the bond at all, that they also impose pretrial services and an ankle monitor. This is a very serious charge, running the streets of Crestview with a handgun, and we ask that the court to take that into consideration.
Anything further, Ms. Etheridge?
Your Honor, I don't believe that Mr. Coleman specifically has an objection to the monitor as long as it can be at $1 a day, if that's what the court.
So, Mr. Coleman, I don't think there's any question, even from the defense, that these are serious matters. And folks need to understand that when you're dealing with guns, it's a game changer. Because in an instant, it could end somebody's life. All we have to do is turn on the TV every day to see that. And not only was the improper exhibition, that's the charge, there's also a charge of possession of a weapon or ammo by a convicted felon. So you knew better to even have that in your possession, or you should have known. I'm sure you did. That's certainly the law. So based upon that, the court's going to deny your motion to reduce the bond, even though the court acknowledges that it is a significant bond, and it may be an impediment to you. Court finds that there is a reasonable basis for that, largely as a result of the importance to protect the citizenry. Okay? Thank you very much.
Yeah.
Akeem Dixon.
Dixon?
Your Honor, Casey Etheridge for Mr. Dixon, and we're here in 2018 CF 2695, 2019 CF 562, and 2020 CF 835, and 2019 CF 1660.
I'm sorry, what was the last one?
20,
2020.
I'm sorry, 19 CF 1660. And
660, that's not on my docket.
1660.
1660, what is that charge?
Well, these are all violations of probation. I apologize. They got set on two different dockets for the same person. I don't know how
This
that,
defendant picked up a new law violation up here on the north end of the county. It has not been filed on yet. He's set for arraignment on the new law with us on the 7th of July. All these VOP cases, it's my understanding that these were violations of probation on the south end. So probably because he picked up a new law here in Crestview, those VOPs are going to be transferred up here. So I'm not sure if those numbers were being included by Ms. Etheridge or not, but
okay.
I'm showing 1, 2, 3, 4, 5 VOP cases.
I've only got 3 cases. I've got 18 CF 2695, 19 CF 562, 20 CF 835. I just want to make sure and keep it.
That's fine, Your Honor. Okay.
If there's additional, I don't mind handling them. I
You
just
might not
want to
have
make
received
sure
them yet.
that we're clear so that the clerk can
Yeah. It looked like
keep
they were
our
set
record
on-
straight. I'm sorry.
According to mine, they were set on 7/7, so that's why I thought that they were already up here. But I don't.
Okay, so what are the other two? So you got
Okay.
19 CF 1660, and then there's a fifth
And,
one?
Yeah, 19 CF 1659.
So all of these have violations of probation that we're dealing with today?
Correct.
Okay, that's fine. I just want to make sure I've got everything.
Okay.
And are they being transferred up here? Is that,
Yes, Your Honor. Once I file on the information here, they'll send all the violations of
Okay.
probation to us.
very good.
Okay.
So I'm sorry. Go ahead now.
Okay. And we're asking to have a continuance on the violations, Your Honor, to probably 7/28 at least. I'm not sure if we're going to be ready then, but we'll do our best to do that. It may, and then we'd also ask if, I guess we can't arraign him because you haven't filed any information yet.
He's set for the 7th.
So we'll continue it to 7/28 without subpoenas in the morning, but we'll be
Yes, sir.
scheduling a trial if, you
Yes.
guys should know where you're at. We'll be scheduling a trial on the evidentiary hearing on the BOP at that point, if you guys
Well-
can't resolve it.
It's based on the new law though, Your Honor, so I mean, I don't know if we're going to have discovery. The information hasn't even been
Okay,
filed.
well,
so-
we'll deal with it
Right,
at that
yeah.
time. You're right, and there's got ongoing discovery issues.
Right.
Okay, very good.
You'll be- So you'll be here on 7/7 and then 7/28.
Okay.
Okay? Yep.
Javaris Durham.
Casey Etheridge for Javaris Durham. If I could just have one moment. Your Honor. He would like to withdraw his, he'd like to admit to the allegations in the affidavit and accept the state's offer of adjudication of guilt, revoke and terminate probation, 240 days in county jail with credit for all time served, $100 cost of prosecution, $150 public defender fees, all fees, fines, and court costs reduced to judgment, and count 2, adjudication of guilt, revoke and terminate probation, 240 days in county jail concurrent with count 1.
State in agreement.
Yes, Your Honor.
Is there a score sheet for the defense?
No objection, Your Honor.
Thank you.
Thank you.
Mr. Durham, I just need to ask you a few questions, make sure you understand what's going on here today. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Sure.
Okay. You heard your attorney state the terms of the plea agreement. Now, a little bit, there's a lot to it, and I want to make sure you understand it, and you've gone over it. So, did you understand what she was saying? Is that what you're agreeing to here today?
Sure.
And I see that you just signed the violation of probation plea agreement that contains all of these in some detail. So, by the core, when you kind of bring everything, boil it down to the essence, the core of the plea agreement on both counts is an adjudication of guilt, revoke and terminate probation. That means you don't have to, when you come out, you're not going to have to deal with probation anymore. 240 days in the county jail for each of them, but they'll run together, concurrent, right? They're not going to be stacked on top of one another. You understand? It's 240 days. You will get credit for time served, and there's some fees and costs, et cetera. Do you understand all that? Is that your understanding of what the plea agreement? And if you've gone over this plea agreement and had all your legal questions answered from your attorney, make sure you understand this?
Sure.
Understand you're waiving the right to go to an evidentiary. You can go to a hearing, contest this didn't happen.
Sure.
You believe that's in your best interest? Why is that? Why do you think it's in your best interest?
Because I'm just trying to get home at this point. I violated probation.
Okay, very good. So, based on that testimony, the court will accept the plea agreement, and the court on both counts on 2419 will have an adjudication of guilt, revoke and terminate probation, and sentence the defendant to 240 days in the county jail, credit for time served on both of those, but they'll run together, okay? All fees and costs will be reduced to judgment that are contained. Question? Okay.
Thank you.
Curtis Farrell.
Casey Etheridge for Curtis Farrell. May I have just 1 second, Your Honor?
Videos, because
Okay. Your Honor, if we could pass this to 728, Your Honor. He has some more questions. Anyway.
Very good. We'll continue to 728. Ms. This will be the last continuance. We'll either
Yes, Your Honor.
settle, plea, or go to a hearing, okay? Thank you. William Frazier.
Yes, register for William Frazier, if I could just have 1 second. Okay, he would like to accept the state's offer, admit to the allegations in the affidavit, and will be sentenced as follows. Adjudication withheld, reinstate community control with same terms and conditions, $100 cost of prosecution, $150 public defender fees, and cost of transportation to Okaloosa County in the amount of $89.16. And no objection to the score sheet, Your Honor. I do have the score sheet.
The state in agreement?
Yes, Your Honor.
Thank you. Mr. Frazier, would you please raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. You heard your attorney state the terms of your plea agreement. Is that what you're agreeing to here today?
Yes, sir.
Okay, you can put down your hand. The court just want to make sure that you kind of had a chance to go over all this with your attorney. You are waiving some rights by entering into this. You can contest this at a hearing, et cetera. You believe this is in your best interest to enter into this agreement?
Yes, sir.
Okay, so you're reinstating community control. There's some fees and costs that are contained in here that'll have to be paid while you're on community control. Do you understand that?
Yes, sir.
Okay. Do you have any questions?
No, sir.
You've been able to go over all this with your attorney, okay? You
Yes, sir.
understand what's going on?
Yes, sir.
Okay, very good. Based upon that testimony, the court will accept the plea agreement, which I see, Mr. Frazier, you've signed this. You went over this with your attorney, right?
Yes, sir.
Okay. The court will continue to withhold adjudication, reinstate community control with the same terms and conditions, and of course, with the additional costs that are contained in the plea agreement. Thank you very much.
Sir.
Your Honor, I just want the court to understand Mr. Frazier is doing a good job. I told him I'd stand up for him if he continued, and he has.
Okay, very good. And Mr. Frazier, understand, that's why, because you've been working hard is why they've reinstated. Okay, you understand what I'm saying? In other words, he's acknowledging it, and the court's acknowledging that you're trying to do the right thing and following the rules. And so that's why we're letting you to continue on that, and hopefully continue to be successful, okay? Good luck. Ryan Galt.
Okay. Can you hold that open?
Yeah, scores.
Okay. In our case, the ethics for Ryan Gall, we're here in 2022 CF 1083, and we're here for a bond hearing on contact with the alleged victim and being able to go home. And Your Honor, Mr. Gall has been living out of his car since his arrest, or since bonding out on the case, Your Honor. And he does have a minor child that he has shared custody with, and he is not able to use his time sharing since he doesn't have a residence. And the alleged victim has filled out a victim input form asking that he be able to come back home, and so we would just ask that the court modify his bond and allow him to
What's
have.
the
no-
current bond?
Sorry. He can't have any contact with the alleged victim, and he has to stay away from the residence. So we would just ask that he be able to go to his residence and have no violent contact with the alleged victim in the case.
Your Honor, the victim did file a statement. She said she would like for the no contact order to be dropped or at least reduced to a no violent contact order. The state would request a no violent contact order. And she wishes for him to have intervention services, counseling, etc. She wants him to be a part of her life and the child's life.
So the victim is who?
Jessica Galt,
Who is? What's
his
the
wife. His wife.
His wife.
So the state would ask for no violent contact with Ms. Galt and to give her the option to decide whether to allow him back into the home. She did not address that.
A little confused on that. You just threw her,
Sorry.
right, you just confused me just a little bit.
Okay, so she's requesting the no contact order be dismissed or modified to no violent contact. The state is asking and is okay with the court modifying it to no violent contact. All right?
Which essentially allows contact.
Yes, just not violent contact.
Right.
They're also asking to allow him to move back into the home. We're saying she did not address that, so we're saying if the court would give her the discretion,
You say she,
Being-
the defense counsel, or the victim?
Miss Jessica Galt, the victim, be allowed to decide whether to allow him back in the home. This is not, she did not address that. It sounds like she would probably allow that, but it's not addressed. So at this point, we would like the court to modify it, to leave it to her discretion as to whether they can work it out for him to come back into the home or not. She says she wants contact, and she wants him to have contact with his child.
Counsel?
I mean, and she wants contact. I mean, that's something, I mean, we've actually had, I guess, I had a conversation with her mother because she works long hours, I believe. Isn't she the one that's a corrections officer?
She's a nurse.
Oh, she's a nurse, and I can't get her on the phone to her hours, even if I try in the evening. And so, but she did fill out that victim input form after I left a message with her mother. And so she wants contact, and I know that she was one of the ones also that reached out that said that he can't visit with his children.
The victim's
Filed?
filed.
Yes, Your Honor. This is dated June 21st, 2022.
I don't have anything in the court file. Can somebody show me her actual statement?
Yes.
I'm hesitating because there needs to be some clarity. We can't leave it up in the air.
Well, Your Honor, I would ask that to the extent that Ms. Etheridge asked the court to allow contact, no violent contact, that he cannot be within 500 feet of the victim's residence, that he can be within 500 feet of the victim's residence. And the state is fine with him being allowed a visit with law enforcement to retrieve his personal belongings.
You don't even know whether she would agree to allow him back in the house. You haven't even talked to her.
No, not
What
specifically, Your Honor.
is it her mother you've been communicating with?
So it's, okay, Your Honor, so I've been given this information, okay? And I had left a message for her to fill out the victim input form because she's unreachable, essentially. And so, because like she's even working today, we couldn't get her off today to come here. And so that's one part of the reason she did the form, because there's, anyway. But, I mean, the whole point of this, Your Honor, is because of his minor child that lives in another state that he can't see if he doesn't have a residence. So that's the, she's asking for contact, and we would just ask that the court, we're fine with her having the discretion to let him back in the home if that's what the state would like, and maybe it involves something where she has to put it in writing and file it with the state, I don't know. Or file it with the court, just.
It shouldn't be this hard. You got to be clear on these things. These are very serious charges when you get imprisonment and these things. They can be not serious, they could be death serious. And the court can't sometimes differentiate it based upon this short statement and even what was contained in the arrest report. So I don't know what that is. She's saying one thing and whatnot. Okay.
Your Honor, we would just ask for the no violent contact.
Okay, I'll grant and allow him to have no violent contact, but, and if we can get clear direction from the wife, the victim, that she allows him back in the home, then I'll sign that as well. You need to get another victim statement saying it's okay for him to be back in the home, but right now, I know that's one of the reasons why you want to do it, but we didn't address it. So.
And Your Honor, would you like me to
The
say-
court is modifying it to allow that he can be, have no violent contact with the victim, but I'm not amending. He does stay away from the victim's home,
Okay, and so if we.
vehicle or place of employment. That doesn't make any sense. That's the whole reason why he's doing this. You guys need to clarify this. Either have him where he doesn't or not, and get me an order. You guys need to clarify it one way or another. If the victim okays it, put it in writing and give me an order, okay? It doesn't make any sense to have him have contact and him not be around a vehicle, not be around the house, not be around employment. It just doesn't make any sense. No violent contact means contact, and it generally travels with it that you can return to the home. That's generally what's done. But it's not clear, so you guys, you need to get it clear. I'm willing to sign it. You got to get the victim to okay it.
Okay, so you would like something in writing from the victim? Okay.
It's okay for him to be, near the residence, vehicle, and, the other
Okay.
stuff that's in there.
Okay, but the lifting of the no contact is in effect right now?
That's what's requested, and that's what the court's granting.
Okay,
I'm sorry, I can't be more, I'm a little frustrated. I want to get it clear, too. I know it's
okay.
difficult. We're not trying to upset people's lives more than they already are.
And a new court date, Your Honor?
We need,
He already has a date for the 22nd.
22nd. Thank you.
Yeah, he had a visit tomorrow, Your Honor, that's the reason that
okay.
he can't visit with his daughter without.
I'm sympathetic, but we need some clarity, I'm sorry. Athena Griffith.
I didn't hear it.
Athena Griffith.
Casey Etheridge for Athena Griffith, and Your Honor, we're asking to set this case for 7/28. I would like to build it.
Very good. We'll continue to 7/28. Is this last continuance? Will we be-
Yes, Your Honor. I believe this was originally set on 7/28 and then got moved up, so, but I'm asking for it to be on 7/28. if we can.
Okay, very good. Colby Hart.
Yeah, that's what Casey Etheridge for Colby Hart, and we're here in 2021 CF 2741, 2022 CF 454. And Your Honor, we would be entering a plea of, I guess we're just continuing it, Your Honor. We're not admitting the allegations today. We have 2 new law violations that are set for
This afternoon, if we could go ahead and do it
this
now.
afternoon. Oh, is he set for this afternoon? Okay.
22 CF. Actually, no, I'm sorry. I apologize. She stuck it in my box, but it's actually set for July 28th. But we could go ahead and address it now. I've already filed on them. We're ready.
Okay, what are the other case numbers?
So the new case numbers are 22 CF 1514, 22 CF 1517.
Okay, so those are new law violations. Is that the
Yes.
basis of these VOPs?
Yes, Your
Yes.
Honor.
Okay. So,
If we could set all of these on 8/22, Your Honor, I think it's going to be something we're going to have to look into the cases
that's
before we're
fine.
ready.
We'll continue to 8/22. We're entering, are you entering a not guilty
Not
on the
guilty
new
plea.
charges?
Yes, Your Honor.
So we can pull them off of the arraignment docket? Did you just get that, Madam Clerk? 24th, thank you, Madam Clerk. It'll be the August 24th for inmates. But we are entering denials of the violation of probation and not guilty on the 2 new law charges. We'll come back on 8/24.
See you. Okay.
Marie Leckler.
Judge, if I could have a moment.
Sure. For this case, we'll take just like a 5-minute break just to stretch our legs. You guys get to get up and move up and down.
Thank you, Judge.
Charles Russell Public Defender's Office, Judges Maria Leckler. Case numbers are 22 CF 103, 22 CF 244, and then she has number 28 on the afternoon docket, 22 CF 1374.
Hold on a second, let me get that. Okay.
On the new case, 22 CF 1374, state has filed an information, so at this time, we're going to enter a plea if not guilty, request trial by jury, and 15 days to file any pre-arraignment motions.
We'll come back on 8/24.
Well, actually, Judge, the state has made an offer. We need to tweak it some, so what I would ask is that all 3 cases be set to 7/28.
Very good,
We anticipate a plea on that day, but we just have to get some stuff straightened out.
very good. So we'll continue all these. We'll enter denials on the 2 VOPs.
Yes, sir.
And then we'll continue to 7:28.
And that'll be.
Without subpoenas, that'd be in the morning.
Yes, sure.
Correct, Judge.
Okay.
We'll see you later.
Very good. I know, Mr. Russell, you're ready to go, but let me just take a 5-minute break, just get them stretched a little bit.
Yes, sir.
We won't drag it out.
That's okay. I can understand it.
And I sent you that email about.
Yeah, so, yeah, I'm pretty sure that's what he's agreeing to. But I mean, yeah.
He's gonna be here too.
Yeah.
I've got to get back to you guys. From the court up here with me. So. Yes.
We're not doing that. Just like the clerk pointed out, that BOP one was actually dismissed.
Christine said, order to get mental health eval and begin treatment last time in court, on primary basis for EOP. The intent was to reinstate with all original terms and conditions plus a year on CC and any treatment recommended from the eval. Didn't get an eval done.
And she said that on the record? There's things I would just never want to say in court, you know what I mean? Like, I don't know, it's just, not going on. Yeah, I'd rather keep all that. Yeah.
All rise, court's back in session.
Please be seated.
Charles Russell, Public Defender's Office. Judge, this is Justin Mays. Case number is 20 CF 881. Mr. Mays has a competency evaluation pending. We ordered it May 16th, so if we could just put this off till July 28th without subpoenas, hopefully we'll have an answer by then.
Very good. Continue to 7:28 in the morning.
Thank you, Judge.
I also got word from my office that Ryan Bielik, who we did a capias on, contacted my office. He was trying to go to the south, and he was on his way up. And so, anyway, we're just going to hold on that. We're going to withdraw the capias and just wait for him to come. He tried to, he did contact my office, and he is on his way up here.
Yes, Your Honor. Thank you.
McKinney.
Charles Russell, Public Defender's Office. Judge, this is Zachary McKinney. Case number is 20 CF 555. At this point in time, we're going to enter denial to the VOP, ask that it be set for July 28th at 9 o'clock without subpoenas. We're going to look into possibly some kind of rehab for Mr. McKinney, but we're going to need some time to.
Very good. Enter a denial. Will continue to 7:28 without the subpoenas in the morning.
Okay, I'll be in touch.
Ryan Peterson.
She hasn't decided yet. The one that's okay. Charles Russell, Public Defender's Office. Judge, this is Ryan Peterson. Case number is 20 CF 1288. Mr. Peterson also has a new law violation, number 22 CF 1404, that is number 41 on this afternoon's docket. And if I could have a moment, Judge?
Sure.
Said no action on the FDA. So she do this.
60 days, right?
Yeah, 60 days concurrent. Judge, on Mr. Peterson's new case, 22 CF 1404, we've got a global plea agreement, but I guess I should enter a plea of not guilty at this time just to kind of take care of that.
Sure.
But we have a global plea agreement to take care
Get that,
of,
Madam Clerk.
to take care of the VOP from this morning and also the new law from this afternoon.
Okay.
So on 20 CF 1288, which is the violation of probation at this time, in exchange for a plea of no contest to the new charge and an admission of violation of probation on the old case, 20 CF 1288. The state's going to ask that the probation in 1288 be revoked and terminated, and the sentence would be an adjudication of guilt, 60 days in the county jail concurrent on all counts, credit for any time served, that he would be assessed court costs in 22 CF 1404, pay $100 cost of prosecution in each case, $150 public defender fee in 20 CF 1288, $100 PD fee in 22 CF 1404, and in 20 CF 1288, he would pay restitution of $1,315 to Frank Smith, 4661 Todd Road in Crestview. He He would have 120 days after release to pay, or it would go to collections, and the state would take no action on the failure to appear. And I also have a score sheet.
That's the state's agreement, Judge.
Very good. And you're in agreement on the score sheet, counsel?
Yes, sir.
Okay, Mr. Peterson, would you raise your right hand? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay, so you heard your attorney state the terms of your plea agreement. Is that your understanding of what your agreement is, and are you in agreement? I see that the written terms were contained in a plea and sentencing agreement that you've signed. Have you had a chance to go over this agreement with your attorney to make sure you have all your legal questions answered? Because this does affect your legal rights.
Yes, sir.
You're waiving the right to go to a trial to contest this. Is that what you believe is in your best interest?
Yes, sir.
Have you had all your legal questions answered? Yes, sir. Okay. And why are you entering into this plea? Okay, very good. Based upon that testimony, the court will accept your plea, and on the 20 CF 1288, the old charge, we're going to revoke and terminate probation, be an adjudication of guilt, and there'll be 60 days in the county jail. You will get credit for time served. The new law charge will also, the new law charge also has the same 60 days concurrent?
Yes, Your Honor.
Okay. So it's a total of 60 days, but it's 60 days for each one. In addition, there are some costs and fees that will go to collections. There'll be no action on the failure to appear. So the core of this is the 60 days. And again, you will get credit for time served. You've been in almost a month already, so it is what it is. So any questions? Okay, very good. Thank you. Anita Smith.
Charles Russell, Public Defender's Office. Ms. Smith's case number, Judge, is 21 CF 2096. And on her case, we have reached a plea agreement in the case. It is a violation of probation. In exchange for an admission of the violation of probation, we've agreed to restore her to probation but modify it. For the next 6 months, she'll be on community control. And then after that, the remainder of her supervision will be on drug offender probation. Cost of supervision would be waived. Any original terms and conditions that were not completed will be reinstated. She would perform 50 hours of community service. She would have a curfew from 7 p.m. to 7 a.m. She would pay a $100 cost of prosecution, $150 public defender fee, and would be adjudicated guilty. I have a score sheet, too, if I may approach.
Is that the state's in agreement?
It is, Your Honor.
And the score sheet you're okay with, Mr.
Yes, sir.
Russell? Okay. Ms. Smith, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay, speak into that mic for me, because I got to hear you.
Yes.
Okay, you can put your hand down. So I just need to ask you a few questions to make sure you understand what's going on and that you're entering this freely and voluntarily. So you understand that by entering into this plea agreement, you're waiving the right to go to a trial, and this is the final resolution of everything?
Yes, yes.
And the core of this, obviously, is you're basically staying on probation, but it's a higher level of supervision, okay? So this isn't the end, this is the beginning.
Right.
Community control is not easy, basically house arrest. I like that term better. It's more descriptive.
Yes.
Are you willing to do that, stay on house arrest?
Yes, I
Community
am.
control for the next 6 months?
Yes.
In addition, the remainder, you'll be on drug offender probation, so you, again, more testing, more supervision. Do you understand all that?
Yes, I
You're willing to
do.
do that?
Yes.
Okay. Do you feel like you've gotten all your legal questions answered about this violation and this plea agreement here with your attorney?
Yes, I do.
Okay. You feel like you've gotten good representation?
Yes, I do.
Okay. Very good. Based upon that, the court will accept your plea and will restore and modify probation. Is that how we're doing it? Restore and modify? Mr. Perry, is that the best way to frame it?
That is correct.
Okay, and of course, the key is the next 6 months on community control with the remainder of the probation on drug offender probation. Waive the cost of supervision, all the original terms and conditions apply, and there will be a curfew from 7 PM to 7 AM. Is that throughout the remainder of probation? Okay.
That would be for community control and the drug offender probation.
Okay, very good. Then you've got some fees and costs that are contained. Okay, very good. Thank you very much.
And
Good
Your
luck.
Honor,
Yes.
in the event she gets a job or something that she works till 9, if you will allow us to adjust that curfew as we need.
Yes. You
Thank
have
you.
that authority. Thank you. Good luck, ma'am.
Thank you.
Talk to your probation officer.
Thanks, Alderman.
Cynthia Smith.
Charles Russell, Public Defender's Office. Judge, this is Cynthia Smith. Case number is 21 CF 1331?
81.
81, sorry.
It's all right.
The violation of probation in our case is based on some new charges out of Walton County. Those charges are still pending, so at this time, we're going to enter a denial. Ask that it be set for 7/28 at 9 without subpoenas so that we can see what happens on the Walton.
Very good. Continue to 7/28 without subpoenas in the morning. Stay in touch with your attorney. Chaz Spencer.
He's an inmate. Judge, this is Chaz Spencer. Case numbers are 20 CF 917, 21 CF 3298, 22 CF 916, and 22 CF 1015. The 2917 and 213298 are violations of probation. The 22916 and the 221015 are extradition cases, basically. The basis for the violation are the extradition cases. When I spoke to Ms. Sandler yesterday, she indicated to me that a governor's warrant had been issued on the extradition cases, and she had also told me previously that once he's extradited, all these cases will get dismissed. So now I guess we're waiting for Ohio to pick him up.
That's my understanding as well.
What do we need to do on this case? We just continue it to 7/28?
If you want a control
Hopefully it'll be
date.
resolved in the interim?
Once he's extradited, we'll dismiss the cases.
How long do they have to extradite me? I've been sitting here 85 days on this second extradition.
Fortunately, we don't have any control over there, what they do. We'd like to, wouldn't we? We'd like to, what state is it?
Ohio, sir.
We'd much rather Ohio have it than us, but we can't control that, so we have to wait. So we're doing the same thing you were. We'll come back on, hopefully it'll be resolved by then, but if not, our next control date is 7/28 without subpoenas in the morning. Okay?
I'm saying, how long do they have to come get me? My parole's over with July 28th. Like, they can't come get me after that anyways.
You've got other charges that they're filing, so.
Do what?
Let's hope that they come pick you up. If not, I don't know. What's the answer to that? How long? Answer his question.
I'm
What-
not, Judge,
do you
I don't
know?
deal with the extraditions. I know that he refused to sign his extradition. The process would have been a lot quicker had he have waived the extradition.
I signed the first extradition for this charge. I signed it.
Okay.
Used later, so I'm not sure, Judge.
No,
Okay.
they booked me a second time on it. I waited the first extradition for this warrant. I waited it out. I waited the 30 days that they said. I went back in front of first appearance, and then they
Mr. Spencer,
were gonna release me.
we're
This
not
is
making any progress.
It's the same warrant.
Okay.
I don't understand how I can keep being held on this, booked on the same warrant twice. I don't.
Because you didn't sign, so,
I did the first time.
okay. Mr. Spencer, I'm not going to argue with you. Go ahead, take it
Like,
back.
could I just be held forever for fun? Like, this shit's crazy as fuck, man.
Fortunately, it's early in the day. Still have a little reservoir of patience. Brandy Stack.
If I could have a moment, Judge. Charles Russell Public Defender's Office, Judge, this is Brandy Stack. Case number is 20 CF 287. She also has a new law violation that's on this afternoon's docket. It's number 45 on your docket. The case number for that case is 22 CF 1458. The state has filed an information, so we'll enter a plea if not guilty. We do have a global resolution for both cases. If she will admit the violation of probation in 20 CF 287 and plead no contest in 22 CF 1458, in 20 CF 287, the probation will be revoked and terminated. She will be adjudicated guilty, sentenced to 90 days in the county jail concurrent in both cases, credit for any time served, be ordered to pay court costs in 22 CF 1458, pay a $100 cost of prosecution in each case, pay a $150 public defender fee in 20 CF 287, a $100 public defender fee in 22 CF 1458, and that she would have 120 days after her release to pay, or the money would go to collections. May I approach?
That's the state's agreement.
Thank you. You're in agreement on the score sheet, Mr. Russell?
Yes, sir.
Okay. Ms. Stack, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Okay. So, you heard your attorney state the terms of your plea agreement. Is that your understanding? Are you in agreement with that? And I see that the same terms are contained in this plea and sentencing agreement that you've signed. Have you gone over this with your attorney to make sure you understand kind of all the legal impact on you of this agreement?
Yes, sir.
I mean, it's a pretty straightforward plea agreement. Obviously, the core of it is that probation is going to be terminated, and you're just going to go to basically a concurrent sentence of 90 days in the county jail for each of the charges. They'll be served at the same time, concurrent. So they're not going to be on top of one another. There's a total of 90 days. You will get credit for time served. Is that your understanding of everything?
Yes, sir.
And you believe that's in your best interest to enter into this?
Yes, sir.
Okay. And you've got some fees and costs that'll have to go to collections, correct? 120 days, you have 120 days after release, and then it goes to collections. Okay. Do you have any further questions of your attorney regarding this?
That's it.
Okay, you got everything answered? You're clear
sir.
this is what you want to do?
Yes, sir.
Okay, very good. Court will accept the plea and sentence you to the 90 days, credit for time served in each of the two, along with the fees and costs to go to collections after 120 days. Good luck, ma'am. Stearns, Christopher Stearns.
Stearns.
Charles Russell Public Defender's Office, Judge, this is Christopher Stearns. Case number is 21 CF 1357. This is a violation of probation case, Judge. It's based on some new misdemeanors that are still pending. At this time, we're going to enter a denial to the violation of probation, ask that it be set for 7/28 at 9 o'clock without subpoenas so that we can see what happens on the misdemeanor charges.
Very good. The court will enter the denial, continue to July 28th without subpoenas in the morning. Stephen Steele.
You got to wait for your misdemeanor to resolve.
They passed it on, okay.
I'll get with your public defender on that case. Charles Russell Public Defender's Office, Judge, this is Stephen Steele. Case number is 20 CF 331. This case was passed to today without subpoenas. In the interim, Mr. Steele has filed a request for a Nelson hearing. I didn't know if the court wanted to deal with that today. He filed it a week ago, June 23rd. Or if you want me to set it for hearing, I can do either.
I'm going to set it for a hearing because,
Okay.
just because we'll be right up against
Okay.
our time. We've got a couple things. We've got a full docket this afternoon.
Okay.
So for the violation here today, are you entering a plea?
At this time, we already entered a denial, Judge, but we'll enter denial again.
Okay. And do we want to go ahead and set the set, do we have any time, you don't have any time in the afternoon, any miscellaneous? August 4th? Okay. We'll do the Nelson hearing on August 4th
And so that'll be
in
at
the afternoon,
2 o'clock, Madam
2
Clerk?
o'clock.
2 o'clock, okay.
So at that time, the Nelson hearing, you'll basically come in and basically argue why you think you want a new lawyer, what the problem is, and the court will make a decision at that time, okay?
Are there any offers for today? Still the same offer standing from last month? Last week?
12.1.
12.1, so what, no 11.29 come down to?
She came down 11.29 last time and you didn't want it.
Right, I'm just asking if it's still there. I mean, would you consider a suspended sentence?
This is a negotiation between you and the state.
Okay.
It's not, I'm not in the middle of it.
11:29 today.
I'll sign 9 months right now if you'll do that.
Nope. 11:29.
Okay. Okay.
Come back August 4th.
Yes, sir.
All right.
Chad Thompson.
Charles Russell, Public Defender's Office. Judge, this is Chad Thompson. Case number is 20 CF 3090. On Mr. Thompson's case, we recently received some information from his mother. Based on that information, I'm going to have to ask for a copy, Val. I haven't filed for it yet, but I'm going to have to order one. So at this time, I just ask that it be passed so I can get that ball rolling.
Okay, how long do we want to schedule it out for?
We can set it for 7/28 if nothing else, and I can give you a status, kind of where we are. That is kind of quick. That's only like 30 days out.
We're going to set it for a miscellaneous in August.
Yeah,
Okay.
let's do it for the 25th. Let's do it in 2 months. That'll give you, I mean, you guys understand the process. You'll get it going, so.
Okay, August 20th.
We'll come back August 25th in the morning, a.m.
Thanks, Judge.
Tobias, well, we'll do Vickery.
Okay, we'll do Vickery first.
Jumped ahead.
That's
all right.
okay.
We can do- Is that Vickery?
This is Vickery.
Okay, let's do Vickery.
Charles Russell, Public Defender's Office. Judge, this is James Paul Vickery. Case number is 21 CF 1510. He's here on a violation of probation, but it's based on an Escambia case that was dismissed, so I didn't know what the state wanted to do.
Judge, the sole violation of this probation was based on an Escambia County domestic violence case. That case was null prost, and based on the fact that that was the sole violation, at this time, the state would ask the court to dismiss the VOP and reinstate him to probation.
So the state's, is it me dismissing or you withdrawing?
It has to be you, Your Honor. I can't dismiss the VOP, but I would ask that the court dismiss.
Okay, so court will dismiss then, at the request of the state based on.
He should be reinstated to all his original terms and conditions of probation.
Okay.
Thank you.
Court will reinstate the original terms and conditions.
Charles Russell, Public Defender's Office. Judge, this is Ashton Tobias. Case number is 20 CF 719. I'm not sure what Ms. Tobias is before the court for, because the clerk pointed out to me that the court dismissed the VOP warrant back on March 16th, and so there's not really anything pending for her, so I don't know what we're doing.
Actually, Your Honor, this was Ms. Tobias's case. This was the one that had somewhat of a misunderstanding. There was a VOP warrant out there. There was a warrant to take into custody. What we ultimately boiled it down to was the court addressed her, what I have here, back on 4/7, that the VOP was set for status on 4/28, and she had denied it. The biggest thing the court told her to do was get that mental health evaluation done before we come back in. That was really what was outstanding, and if that mental health evaluation got done, then basically she would be reinstated and all with all the original conditions that the court had ordered back on 7/8/21. So the court gave her that time to do that. They withdrew the VOP warrant to take her into custody, but the VOP was standing. That was our understanding, and the real basis was because she hadn't done the mental health, so the court gave her that time. We came back in on 5/26. again, for the VOP, and to get a status from Ms. Tobias. And our understanding at that time was that while she had tried to get it done, she hadn't yet, so the court gave her additional time until today and reset it. So the only thing she had been ordered to do as a condition of being out on the bond was get that mental health evaluation done and give the court a status on where she was. So that's what I believe, at least the state believes, what we're here for today, is we have a VOP that's outstanding, but the real reason that we're here is because the mental health eval hadn't been done.
She had the evaluation, Judge.
Your Honor, we would ask then that Ms. Tobias get with her probation officer and get some proof with that, and because our recommendation, of course, the original court order was that she get it done and then follow any recommendations and treatments. So if we could get that moving along, get the right parties involved, then I think we're all on the right track.
What do we need to do today as far as what does the court need to order or does the court need to take any action today?
Your Honor, we're just asking her that she go ahead and be reinstated to all the original terms and conditions. In other words, that the court advise her that she's still on probation with all the original terms and conditions. We won't pursue the VOP as long as she provides proof of that to her probation officer.
And they're checking on the proof right
Your
now.
Honor, we'll check right now and see if she provided that. She said she has, and we'll check right now.
In that case, we're okay with withdrawing the VOP and just making sure she understands that we're back to square one, original terms and conditions, follow up.
Okay, so you understand you're back to original terms and conditions
Yes,
and
sir.
follow, and most importantly, follow up with whatever comes back on that eval.
Okay.
Okay, so they say you got to do this, you got to do that. And, you know, it takes some time to get it scheduled, but you got to get that done.
Yes, sir.
Mr. Barry?
We just got confirmation that she has done it and that she has provided that information to her.
Okay, very good. Stay in touch with your probation officer.
Thank you, Your Honor.
Okay, thank you. Walker, is it Chisha?
I believe so, Judge. Charles Russell, Public Defender's Office, Judge. This is Chisha Walker. Case number is 21 CF 969. Ms. Walker is before the court on a violation of probation based on some charges out of Palm Beach County. At this time, if I could have a moment.
Can I speak, please? If, I don't know.
Let your attorney speak and kind of frame it, and if you want to say, I'm not going to keep you from speaking, but why don't you kind of frame the issue for me, Mr. Russell?
Judge, at this time, we're going to enter a denial to the violation of probation. We need to look into the case that's pending in Palm Beach County, which is the basis for the violation of probation in our case. I was going to ask that it be put to 728 without subpoenas. I've advised Ms. Walker not to talk about the case because of the fact that everything's being recorded and anything she says can be used against her.
You want to say something?
Yes, sir.
Okay, hold on a second. Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
You understand that this hearing's being recorded?
Yes.
And you understand that by you speaking, you're essentially giving up your right, well, you're not giving up the right in the future, but for this purpose, you have the right not to testify or not to say anything. You're giving up that right, and potentially, what your attorney's telling you is, potentially you might say something that's being recorded. You know, you hear on TV, the Miranda rights, anything you say can and will be used against you in the court of law.
Yes.
Okay. You see those prosecutors over there? See
Yeah.
those pens in their hand? You know why they got the pens in their hand? Because they're going to write down anything they think you say is going to hurt you. But if you want to say something,
Yes.
fire away.
Yes, sir, I do.
With that, you good with that? You understand all that?
Yes.
Okay, what do you want to say?
I'm actually confused about you all saying that you trying to look into the charges in West Palm Beach. When I was down there, they actually let me go on OR because they didn't have no jurisdiction over Okaloosa for the violation.
Okay, so here, let me explain. Okay, I'm going to cut this short for you. You may not fully understand this, but if you listen to your attorney, because he probably explained this to you as well. When you're on probation up here, one of the criteria for your probation is that you not pick up any charges.
Yes, sir.
Okay, so apparently, you picked up a charge, and it may be dismissed and everything, that's what's being looked into. But you picked up a charge, and therefore, that triggers a violation of probation. Your attorney is denying that so you have the opportunity to look into it. But right now, there was a charge, it triggered a VOP, got to look into it.
That's why I flew up here to turn myself in to get everything straightened and handled out. So that's what I was.
Well, hopefully, they'll get everything straightened out. If you don't have any charges down there, then certainly you'll be, if she finds out there aren't any charges, let's, get her out, for sure, okay?
Yeah, but what I was, another thing is that I just got diagnosed with cervical cancer, and I need my.
What do we need to do as far as finding out, what's the status of
I
down
didn't,
in
yeah, see,
Palm
and that's
Beach?
why.
Hold
I'm
on.
sorry.
Judge, the last information I have is that the state attorney's office in Palm Beach filed on possession of a controlled substance, and that case is still pending.
I never went to court or anything for it as of yet because I had the violation here. And so I came to turn myself in here before I never went to court or anything on that yet. So I thought I'd just probably get reinstated and go back and handle those charges and.
And if defense counsel can provide me with any type of dismissal, I'd be glad to reinstate her if that's her only violation.
Yeah, it is, and that's why I just, I came to do the right thing, so therefore, that's why I was confused as in, why am I gonna, stay being held on, something that I haven't even started to go to court yet. And I finished everything for probation. I've actually paid all my charges.
Counsel approach.
Yeah, I have nothing to.
Is this Mr. Bielik? Is that Bielik? Okay.
Judge, if we could pass this and come right back to it, that would give me a chance to.
Okay, very good. Kenneth Webster.
Your Honor, we handled Mr. Webster's motion for bond reduction yesterday already.
Right, and he was passed to the 824 pretrial conference
Very good.
date.
No Webster. We don't need Webster. Whitaker, Patricia Whitaker.
Charles Russell Public Defender's Office. Judge, this is Patricia Whitaker. Case numbers are 22 CF 406, 22 CF 440, and 22 CF 1014. Could the state and I approach, Judge? It's
You may.
here in our bond motion.
Sure. Mr. Russell, would you announce, and I think you have a request.
Yes, Your Honor. Ms. Whitaker is here on case number 22 CF 406, 22 CF 440, and 22 CF 1014. Ms. Whitaker also has a pending misdemeanor case for the clerk. Case number is 22 MM 266. We had set the cases for a bond hearing, and what we're requesting that the court order is that Ms. Whitaker's bonds be set to an ROR to a Baker Act evaluation with a detainer on her if she is released from the Baker Act facility, and that to cover all cases so that hopefully she can get some help down there.
State leaves it in the discretion of the court, Your Honor.
Based upon the unique circumstances of this case and the condition of the defendant, the court will grant the defense's request, grant the change in the bond as requested to an ROR to a Baker Act evaluation with a detainer as requested by the defense. For all four cases.
Thank you, Judge.
Okay. Thank you. Good luck, ma'am. Last is Whitted. Not last, we got one other one.
Judge, this is Daniel Whitted. Case number is 21 CF 3051. Mr. Whitted is here on a violation of probation. This is our first appearance on the violation of probation, so at this time, we're going to enter a denial and ask that it be passed to July 28th at 9 without subpoenas to give us a chance to work on it.
Court will enter a denial, continue to miscellaneous on July 28th without subpoenas in the morning. Thank you very much. Did Bielik ever show? I told my office he was on his way. So there's a capias, and that needs to be issued.
His girlfriend this morning, that's who I called, and she said that his mom.
Well, I mean, that was long. I mean,
Right, yeah.
We'll deal with it, because if he shows up, we'll deal with it. Okay. Okay, could I ask, just for this afternoon's, what are we anticipating? I know we've got Ms. Gooden's case that we need to deal with, but I was just kind of wanting to look at our afternoon docket just to kind of see, make sure we're all on the same page as far as where we're going.
Mr. English's sentencing was set off.
I'm sorry?
Mr. English, he was on for the afternoon.
That's correct.
He was reset.
And I think Damien Crooks,
He pled yesterday, Your Honor.
right. David Latham, which is first up.
He's the one that he indicated a couple of days ago he was going to take the state's offer. He was not represented by an attorney. He was having some health issues, so he said he would come back today and enter a plea.
Okay. Okay. And Samuel Mosley?
Your Honor, that's the case that I have with Mr. Rudy Harper. In that case, he had not filed the motion to transport his client, so his client is not present. I believe the court has already ordered or signed an order to transport for the 728 docket. And I believe the court had denied Mr. Harper's motion to continue due to the lack of transport, but we have no objection to the court continuing it to the 728 so that, of course, his client would be present since he'll need to be there.
Yeah, I mean, we've got to have him present.
So
Okay,
should we just
we'll
plan on-
we'll deal with that this afternoon, but thank you for giving me that update. So Shannon Beck, we've got 3 other VOP evidentiaries that are scheduled.
Yes, Your Honor. Shannon Beck, that should be a plea. Jonathan Gates, I believe it is, that should be a plea. And then Marion Holmes should be a plea as well.
Okay. Very good. Okay, I think the last thing we've got this morning then is we've
Your Honor,
got,
I actually have an inmate still that needs to be
I'm sorry.
recalled. And then
Who
there's
is
somebody
it?
here from the 1:30 docket in the audience as well. Anthony Bristol.
Okay, very good.
He was here this morning, we just had to do his sentence agreement. So. They take him back already? Okay. Can we get him set for tomorrow, Judge, because he was going to take community control today, so,
Is anybody coming over this afternoon?
yes. Okay, can we get him this afternoon? That's fine.
Let's just bring him back this afternoon if you're bringing any.
Appreciate it.
I wouldn't want to do it a separate trip, but if you're bringing somebody, let's go ahead and get him out of the way.
Okay.
Okay.
All right.
And we'll come back this afternoon on Bristol.
Thank you. And then Nolan Chesser, he's on the 1:30 docket, Your Honor. It's 2022 CF
What number? Hold on a second.
1321.
Shepard, you can come forward. Hold on.
He mistakenly thought he had to be here at 9, so.
Better early than late, right?
That's correct. That's his. Charlie, do you have Walker? Are you recalling?
Tisha Walker. Judge, we can do either. I've talked to the state. We do have a plea agreement, but I'm going to need to go back there and just talk to her.
Let's go talk to her now, and then we'll bring her back right after lunch. We got a couple others. We'll have time.
Okay, that's fine with me, Judge.
Okay. I'm sorry, what? Give me the name again.
Nolan Chester, 22 CF 1321.
Spell, I'm not following.
Chesser, C-A.
I'm on the plea day docket. What number? 12? Chester. Okay, now I got it.
Casey Etheridge for Nolan Chester. He would like to enter a plea of no contest, accept the state's offer. It'd be count 1, adjudication of guilt, credit for time served. Count 2, adjudication of guilt, 3 years of probation, cost of supervision waived, $515 in court costs, $100 cost of prosecution, $150 public defender fees, no possession or consumption of alcohol or controlled substances without a prescription. He must obtain or clear driver's license to the extent possible. Early termination after 12 months of probation if all terms, including clearing driver's license to extent possible, are complete with no violations. And then count 3, adjudication of guilt, 3 years of probation concurrent with count 2, and count 4, adjudication of guilt, credit for time served. May I approach?
You may. State in agreement
That's correct, Your Honor.
in the score sheet?
No objection.
Okay. So, Mr. Chester, would you please raise your right hand? Just need to ask you a few questions. Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Sir.
Okay. So you heard your attorney state the terms of your plea agreement. Are you in agreement, and did she explain it properly? And I see that you have signed a plea and sentencing agreement that contains these same terms in writing. It's got some other stuff in there. Have you gone over this plea and sentencing agreement with your attorney?
Yes, sir.
Make sure you understand what's all the legal ramifications of this?
Sir, I got it.
Okay, you understand that you're waiving the right to go to a trial. This is a final adjudication. It affects your ability to appeal. All those, you had all those questions answered by your attorney?
Sir.
Okay. And you believe this is in your best interest to enter into this agreement?
I do.
Why do you believe it's in your best interest?
Just to get it over with and go on. I'll get my life back in order.
Very good. Okay. Based upon your testimony, the court will accept your plea, and there'll be an adjudication of guilt on each of the 4 counts. The count 1, attachment of an improper tag, and number 4, possession of paraphernalia. Those will be credit for time served. Those are done. The other 2 charges, the driving on a suspended and the possession of a controlled substance, those will each have 3 years of probation. They'll be served concurrent, so they'll run at the same time, right? 1 3-year term. And there'll be a number of court costs, et cetera, that have to be paid during the probation period. Early termination, she explained that. That's a part of this as well. So, do you have any further questions, either of your attorney or of the court?
Sir.
Very good. Good luck. Thank you. Okay, get fingerprinting, I think. Okay, I think, Ms. Gooden, you're finally up.
Thank you, Your Honor.
Hold on just a second. Okay. So, Ms. Gooden, I believe you're inviting the input of the court regarding a possible sentencing.
Yes, Your Honor. Cheryl
that-
Gooden for Eldon Garlow in case number 21 CF 546. Before you is Mr. Garlow. He's 63 years old. He has no prior criminal record. He has 9 counts of possession of child pornography. He scores 32.4 months state prison with a maximum sentence of 45 years. The state's original offer was 7 years. She came down to 5 years. However,
So what is it? What's the offer?
the offer was 5 years state prison with 15 years sex offender probation. Ooh, let me find it.
State's original offer was 7 years DOC, followed by 15 years of sex offender probation. We came down to 5 years Department of Corrections, followed by 10 years of sex offender probation.
Followed by what?
5 years in prison, followed by 10 years of sex offender probation.
My client has a double bypass, double
Dual
chamber
Pacemaker.
pacemaker. He also has kidney issues that he's seeing a specialist for. He's on 15 different medications for his heart and his medical issues. He also cares for his 76-year-old wife who has dementia. He is the sole support of his wife and himself. He did retire last year to take care of her. The only issue in mitigating circumstances or reasons for a downward departure we're arguing is the capacity of the defendant, the defendant requires specialized treatment for a physical disability, and he's amenable to treatment. He has been getting treatment for his kidneys and his heart. My client, although he maintains his innocence, is willing and amenable to serving the probation, but if he goes to prison, then his wife, who is from the Philippines, has nobody here to take care of him. They don't have any children. They don't have extended family. She'll become a ward of the state as she has no financial support of her own. And we're asking the court if it does consider the fact that he does have a dual-chamber pacemaker or his kidney failure issues. And I can provide the court a copy of the list of medications. I was not able to, if I may approach,
You may.
I was not able to ascertain from the Department of Corrections whether all of the,
I mean, just for the record, you've got 15 medications here. I don't have a clue what any of these 15 medications are, other than there's 15 of them, and they have names that I'm totally unfamiliar with.
and my
So just
client,
for
my
the
client
record.
can testify to what each one is for. But generally, the Department of Corrections do not cover or have all of the medications. From my previous clients, if they've come off the street and they've had medical issues. So we're asking if the court does find that his medical issues qualify for a downward departure.
Is that anything further?
No, Your Honor.
Counsel for the state.
Judge, first, we would note this wasn't really set for a sentencing hearing today.
Not a
Second,
sentencing. This is not a sentencing. This is an invitation for a suggestion. And let me be clear. First of all, this court wouldn't even be considering this type of invitation, except that it was made not through any suggestion or any other manner by the court, but it's a request of the defense. It's the only reason the court's doing it.
Yes,
And let me say, before you even comment, as a predicate, what I will provide is based on extremely limited information and is in no way definitive. And quite frankly, will very likely change. And certainly, you need to understand, sir, that anything that I say to you, you can't take it to the bank, because it could change, because I have extremely limited, literally, we're dealing with 10 or 15 minutes. I have very limited information as it relates to that. So this is just, a little bit of input on behalf of the court. It should not be and cannot be definitive in any manner. So this is just a suggestion, because I don't have all the facts. I'll have much more facts at a formal sentencing. I mean, we don't even have a pre-sentencing investigation done. So we're really at an early stage.
And I did ask probation, and they said they don't do them unless they're actually ordered.
Counsel for the state, with that,
Judge,
those caveats and understandings of kind of what's going on here today.
yes, Judge. We would note that the list provided medications was typed. There was no letterhead or any sort of authenticity attached to it. In addition, this case involves an IP address investigated for known hash values of child pornography. 9 images were found during a triage of a spare room when they executed the search warrant. Videos of children as young as 8 were located. The defendant and his wife were the only ones who had access to the computers, and the defendant indicated that his wife typically used her phone for internet purposes. The spare room it was found in had some NFL memorabilia in it and other indications that it would be more of a male-dominated den or area. In addition, as far as a downward departure, there's always a 2-part basis. First, whether the court can depart, that is, whether there's a sufficient legal basis, and secondly, whether it should.
Would you repeat what you just said?
Sure. In order to qualify for downward departure, it's a 2-step basis. First, whether the court can depart, whether there's a legally sufficient basis, and secondly, whether the court should. State submits in this case it absolutely should not. We would also note that to qualify for a downward departure based on specialized treatment for a physical disability, there also needs to be a showing that the defendant is amenable to treatment. and there has been no record of that placed today. So the lowest the state is willing to go is the 5 years Department of Corrections.
And Your Honor, it was our intention to get all of his medical records and everything to present to the state attorney, if we.
This is not
Right, right, but she said regardless of what we presented to her, she wouldn't go on below the 5 years, so he did not get them for today. And as far as the list of drugs, my client has documentation on letterhead from his doctor regarding his heart condition and his kidneys. He'll have more information next Tuesday, as far as the severity of the issues with his kidneys.
Anything else?
No, Your Honor.
Your Honor, if I may, my client reminded me he wanted the court to know that he served with the U.S. Air Force and the military, 43 years total, 26 active and 16 in civil service.
The court has reviewed the arrest documents, which outlined brief summaries of what were contained on the that led to the 9 separate counts. From my very quick perusal, my knowledge of the law, each of those 9 instances represent essentially major sexual abuse and abuse of a child. All 9. All 9 bearing very serious repercussions. And that's why these cases are dealt with individual counts, because that image isn't just an image in the sky. That image is an image of a child who actually has been severely abused. And that image represents not a one-time event, but a lifetime. Those images represent a lifetime of trauma that those young girls who will become adults one day measure. I didn't hear anything really seriously contesting. If you want to contest these criminal charges, Mr. Garlow, you have every right to do so. And the court will, you will be treated fairly in the conduct of a trial, and the state has to prove their case beyond every reasonable doubt. If you go to sentencing on this 5 and 10 is eminently reasonable. Eminently reasonable. I don't know if that's helpful, but again, what I would say to you is that this is based only on what I have before me. There could be a lot of other information, could totally change. So this just is a snapshot of a few issues, and it needs to be considered only in that light. So that's all the court has to say about that.
Thank you, Your Honor. May I retrieve the list?
You may. Okay. We will reconvene at 1:30 today.
Your Honor, this is scheduled for tomorrow. I thought that today was going to take the place of having to come back tomorrow, or may I appear without my client?
Is there a waiver? Is this for?
There is a waiver in the
You're
file.
for docket day?
No, it was, we announced with subpoenas, and it was set on today for us to have this hearing, and then.
What do we have tomorrow?
Tomorrow's docket day, Your Honor.
Right.
Oh, okay.
Tomorrow's just a docket day, so I don't know where are we at as far as we
I
set it, we set things for docket day for several reasons. One, because sometimes people need more time in order to talk about a possible plea. The other is that we're gearing up for a trial. I don't know, are we? Are we gearing up for a trial? We ready for trial?
We're ready for trial.
Ready for trial? You
I'm
ready for trial?
trial.
Okay, well then we're either going to have a plea or we're going to have a trial. How long do you all anticipate a trial lasting? Do you all have a guesstimate? I'm not going to hold you to it.
I anticipate 3 or 4 witnesses.
Be more than a day.
Okay, so I mean, that's, I don't, like I say, I'm not going to hold you to it, but I just want to just get a general feel. So essentially, our docket day tomorrow will be, if both sides are ready to go, you can either come to an agreement or we'll proceed to trial.
All right.
Yes, Judge.
But my client doesn't need to be here tomorrow.
Your client absolutely needs to be here tomorrow. Tomorrow is a key phase. He absolutely needs to be here.
And the state's
Docket
offer will
day.
be open until tomorrow.
Pardon?
The state's offer will remain open
That's
until
right.
tomorrow.
All pleas, all offers go off the table, absent exigent circumstances, my favorite word. But as a general rule, the offers end on docket day. So, because we have come back for one jury review, one more day before trial, but, judges handle that differently. We're trying to get, we want to get good, hard offers out. The problem the state has, and they've convinced me, is that if they're ready to go for trial, they need to know so they can get subpoenas out.
Correct.
So the offer will be ending tomorrow, and that's just a general rule. So you probably need to come back and have good conversations, figure out how you want to proceed with this. Okay?
Thank you, Your Honor.
But it's important, it's critical that the defendant be, under very clear rules, any significant, and this would be deemed significant, any substantive hearing, the defendant must be available, so, for his protection. If not, you'll be looking at a 3.850 in a
Yes,
few
sir.
months.
Yes, sir.
If it ended up
I
badly
just
for your
didn't know
client.
if we could handle it today.
I would rather you come back and,
Yes, sir.
unless you all know where you're going, if you're ready to announce ready for trial, we'll do ready for trial, but your offer's are you ready to, you say you want to deal with it today? You want to deal with it? How do you want to deal with it today?
Ready for trial.
Ready for trial? Ready for trial?
Ready for trial, Your Honor, if
Very
we just
good.
put on the record that he's formally rejecting the offer of 5 years in the Department of Corrections, followed by 10 years of sex offender probation.
Correct? Okay, very good. We will,
And if
so
you
we'll
put
be,
him
when
under
is jury review? 7th? Okay. Jury review will be on the 7th.
And Your Honor, if you want to place him under oath and have him state for the record that he's rejecting the state's offer.
Sure. Would you please raise your right hand, Mr. Carlo? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Okay, so we have docket day scheduled for tomorrow. Your attorney stated, just really out of efficiency, that we can handle those things today. Normally, tomorrow, your plea offer would be good through tomorrow. But your attorney's saying you're rejecting the offer, you want to go to trial. Is that what you want to do?
Yes, sir.
Okay. But mainly, the thing I want to ask even more, kind of the behind question is, are you sure you don't want to talk with your attorney further and come back tomorrow? I want to be clear, you're not being coerced arm twisted, anything, because they are revoking their plea here today, not plea, their plea offer
I understand, sir.
today. Okay, so you're good with that?
Yes, sir.
Okay, and you're rejecting that plea offer?
Yes, sir.
Okay. So we'll come back on juror review on July 7th. Again, important day. You need to be there in person, and we'll be, that's where we'll decide what's the order of trials and how we're proceeding with that. And the state, of course, in the interim, can get their subpoenas out.
And I'm going to be here tomorrow, Your Honor. I wasn't trying to get out of an extra
No,
court date.
no, you're
I'm
trying to
here anyway.
operate on behalf. I just don't want to inadvertently,
Yes, sir, Your Honor.
what I really wanted to be clear about is that we didn't do this, and then you say, well, I really wanted to talk with her some more before I did this, and you're telling me, no, you're good, you don't need to talk with your attorney, you're good with rejecting the plea, and you're ready to go to trial. I'm sure you've had many conversations with your attorney about this very issue. I just wanted to make sure, because you have a right to, that you didn't need a little more time. Because you've got it, if you want it tomorrow, we can come back tomorrow, no problem. Okay, very good. So it's rejected, pleas being withdrawn, we're ready for trial. No need for docket day tomorrow. We're coming back on July 7th for jury review.
Thank you, Your Honor.
Thanks, Judge.
Okay, thank you very much. We'll see everybody at 1:30.
All right.
Yes. Rudy's coming. Rudy's going to be here 1:30, so maybe we can.
may need it after.
It helps, to have it, then it doesn't rain. It only rains when you don't have it.
Right, exactly. Yes, good point. Ryan Miller?
I mean, your arrest is gonna be on there no matter what, just so you know.
Just en route to the courtroom, please make sure your cell phones are turned off or on silent.
So do you have the first time about?
She.
Sector.
Mr. Beal? Lunch. And he did, good.
Yeah, that got doubled.
Chase? Did you see Chase?
Chase. I have not seen him yet.
That has PD, but I was telling him that it's theirs.
No, I have a file on him.
You do?
Yes.
Did he get a new case?
Okay, so it's a two.
All rise,
Yeah,
court
that's-
back in session.
Do you have Chase Stewart?
Please be seated.
Okay.
Please be seated. Hey, good afternoon. We are continuing with our miscellaneous criminal docket day. This portion of the docket is the arraignment portion of the docket, so many of you are here for the first time following following your arrest or the filing of the criminal matter against you. The one thing I would say to you, and the purpose of today's hearing is just to make a plea. Possibly there are some conversations as far as possible plea agreements, but as a general rule, the main purpose for today is to make a plea, guilty, not guilty, no contest, etc. Many of you I see on the docket do not have an attorney. As a general rule, except in a few more or less rare circumstances, you always want to be represented by an attorney in a criminal matter. If you do not have an attorney, I'm going to ask you whether you want to have an attorney. If you cannot afford one, one will be appointed for you. However, for today's hearing, if you don't have an attorney and the court appoints a public defender, I'm going to go ahead and issue or go ahead and accept a not guilty plea on your behalf because you haven't had a chance to talk to your attorney before taking any other action that may affect your rights. So again, if you don't have an attorney, you still need to come forward. The case will be announced. I'll ask you if you want an attorney. if you get an attorney appointed, I'm going to go ahead and enter a not guilty plea for the most part. There may be a few situations where there may be some offers that are being discussed, but for the most part, we'll enter a not guilty plea. So with that, so when I call your name, if you wouldn't mind, please coming forward to the well as quickly as possible so we can get through with this. We'll begin with Jared Atkinson. Jared Atkinson. Okay. State. Jared Atkinson.
He was here this morning.
He was here this morning?
He sure was, Your Honor. And he, knowing him, he'll probably sashay in a little bit later.
Marky Allen. Oh, that's in jail. They're not back yet? Oh, okay. Yes, sure. Hold on. Would the state please announce?
Your Honor, this is Nicholas Bennett on 22 CF 1337.
Go ahead and stand over at the podium.
He is charged with possession of a controlled substance and possession of drug paraphernalia.
And Your Honor, we have an offer. I announced his name earlier, didn't know he was here, so I have an offer to go over with him. If we could just pass this.
Okay, we'll pass. Amanda Booker. Amanda Booker.
Your Honor, she's before the court on 22 CF 1229.
She's not here. She's not here.
Not here.
Your Honor, the state would request a capias.
Ms. Etheridge, information?
We have no legal objection. I haven't had any contact so far, so.
Court will order a capias. No bond at this point. Get her back before the court. Hayden Brown. Hayden Brown. State.
Your Honor, the state will request a capias.
Court will issue a capias. Kelvin Brown.
Casey Etheridge for Kelvin Brown. We're here in 22 CF 1420, and we would be entering a plea of not guilty today, and we'd ask for the August 22nd pretrial conference date.
You're good. Not guilty, August 22nd at 9 a.m. I'm just going to make a general statement. I'm not picking on you, Mr. Brown. If I got to wear this silly robe to court, you all got to wear long pants. That's the least we can do. Honor the court. Please don't come in here in shorts. I know it's hot outside, but got to have some like basic decorum. Again, not picking on you. You're just the first one up. James Carnes. James Carnes. Where did I strike it out here today?
Your Honor, I have that it's notated in the file that, and I do not know if this is correct, but that James Carnes also goes by Joshua John Lambert Albright. Now, there was a Lambert Albright on the docket yesterday.
That was Lucas.
That was a different one? Okay. State would request a
James Carnes.
State would request a capias.
I'll check also, Judge.
Thank
Sure.
you.
Court will issue a capias. Terry Chesser. Terry Lee Chesser. Cheshire.
Casey Etheridge for Terry Chesser.
This is 22 CF 1230.
And Your Honor, we would, may I pass this for 1 minute? I do have an offer to go over with him as well.
Okay. Douglas Corman.
Please go back and have a seat.
Mr. Corbin is before the court on 22 CF 1317. He is charged with possession of controlled substance, possession of drug paraphernalia, and tampering with evidence.
Your Honor, we would be entering a not guilty plea for today and ask for August 22nd pretrial conference.
Court will enter a not guilty plea, and we'll come back on pretrial August 22nd at 9 a.m. Charles Detz. Charles Detz. State.
Yeah, my office just called.
Your Honor, would you say that again?
Charles Detz, D-E-T-Z, 22 CF 1243.
I have it on my.
Oh, this is
Huh.
22 CF 1243, Judge.
Mr. Detz appears not to be present.
Judge, he was released on a cash professional bond May 13th. The state would ask for a capias with no bond.
So ordered. Jolanta Durham. Could you announce the case, please?
This is Jolanta Durham before the court on 22 CF 1284. He is charged with possession of a controlled substance.
Mr. Durham, as I stated to you earlier, you do have a right to an attorney. You wish to have an attorney appointed, you're going to hire private counsel.
You know, attorney.
I'm sorry?
Attorney?
You want an attorney appointed? Is that a yes?
Yes, sir.
Thank you. Court will appoint the public defender. And as I stated before, the court's going to issue a not guilty plea on your behalf and give you a chance to meet up with your attorney. We'll come back on pretrial on August 22nd, 9 a.m.
Your Honor, he may want to stick around. I can show him the offer. I know the public defender has indicated they have a conflict, and that they had to refer one of his relatives' cases out.
His case.
His case out?
His case, I can't do him, yeah.
Yeah, referred it out to Regional Conflict Counsel, so that would mean that his case would actually need to go to a private attorney.
Not or, no.
They've already conflicted out. There's a Sebastian Durham, a Willie Durham, and a Jolanta Durham all arrested at the same time and in the same location.
Okay, so what are you proposing that we do today?
You can appoint an attorney, but I did want to show him this first, see if that's what he wants to do.
Why don't you go ahead and announce it?
The state is offering on his particular case a withhold of adjudication, court cost of $615. It would be payable within 180 days. You're more than free to get an attorney, okay?
Okay,
Get an attorney?
okay.
He does want an attorney.
Court will appoint the appoint the attorney. You're going to have to, you want me to appoint, and then you have to get off, right?
Yes,
So
sir.
I'll appoint the public defender, enter a not guilty, but you'll end up getting appointed a private attorney. Okay, but 8/22, put that on your calendar, August 22nd. Willie Durham.
Casey Etheridge for Willie Durham, he's approaching, and we'd like to enter a plea of no contest today and set this for the pretrial conference in August 22nd.
Think you want to enter a not guilty?
Yeah, I thought I said a not guilty plea, I'm sorry.
You said no contest.
Oh, I'm sorry. Not guilty plea, please.
Court will enter the not guilty plea, and we'll come back on pretrial August 22nd at 9 a.m., okay? Stay in touch with your attorney in the interim, sir. Betty Hicks.
And Your Honor, this case was null prost by the state already.
Okay. Michael Huertas, if I pronounced that correctly. Mr. Harper, I think this one says that you guys, the ORCC was appointed.
There's already a not guilty plea.
Okay, you're way ahead, okay? So there's a written not guilty, and we'll just come back for, obviously, pretrial on 8/22, 9 a.m., August 22nd.
Yes, sir, Your Honor. Thank you.
Okay, be in touch with your attorney in the interim, okay? Kevin Josie.
Casey Etheridge for Kevin Josie. We're here in 2022 CF 1289. I believe there may still be a second case on the docket, but they've been consolidated into one. I don't know if it's still on there or not.
I've got two, 1306 and 1289.
Yeah,
Those been
1306 I believe,
consolidated?
was consolidated, yeah.
Okay.
Okay. And then, but we would enter a plea of not guilty today and ask for the pretrial conference date, 8/22.
Very good. The court will enter a not guilty, come back on pretrial, 8/22, 9 a.m., okay? Joseph Leduc.
Judge, this is 22 CF 1421.
That's our case, Judge. Joseph Leduc? No response, Judge.
They would ask for a capias.
Court will issue a capias.
No bond or first appearance, Judge?
No bond.
Okay.
Got to show up.
Yes, sir.
Catherine Lott.
Catherine Lott?
Inmate. No, I don't have her as an inmate, but is inmate? Okay. Lott's an inmate, so we'll wait for.
Okay.
Is she coming over, Marnie? Is Lott coming over? Catherine Lott. I don't have her as an inmate.
Showing she was released May 14th on a $5,000 cash professional bond.
Can we confirm she's in or out? Okay. She's in custody?
She's got arrested
Oh.
yesterday.
Released and arrested again? Is there any way we can get her over? Okay. We'll try and get her. Okay. Ryan Justin Miller.
Charles Russell, Public Defender's Office. Mr. Miller is present and approaching judges. This is case number 22 CF 1293. The state's filed an information. At this time, we're going to enter a plea of not guilty, request trial by jury, and 15 days to file any pre-arraignment motions.
Very good. The court will grant, or not grant, but accept the not guilty plea, come back at the pretrial, August 22nd, 9 a.m.
Thank you, sir.
Thank you. Lawrence Moore.
He's in custody, Judge.
He's in custody also? Okay.
Yes, sir.
You have, I don't have, you have that one? He's on the list, okay. Tyshawn Morris. The state announce, please.
This is 22 CF 1436. Tyshawn Morris, there's not been an information filed yet, so if we could just reset this.
Okay. So our next arraignment of, okay. So we'll come back on the arraignment, a rearrangement on July 7th at 1:30, okay? Thank you. Julius Myrick.
Judge, this is 22 CF 1308 and 22 CF 1310.
Okay. So, Mr. Myrick, you do have a right to an attorney with these charges. Do you wish to have an attorney appointed, or are you going to hire private counsel?
One appointed.
Court will appoint the public defender in both the cases, and the court will enter a not guilty plea, as I stated. We'll come back on 8/22 for pretrial. Try, be in touch with your attorney in the interim, okay?
Yes, sir.
Thank you, Judge.
Thank you. Hunter Nichols.
Twenty-two CF 1369. Your Honor, if we may pass this case, I do have an offer for Mr. Nichols. I don't think he has an attorney yet.
Okay. We'll pass this. Just listen to what they got to say. Okay. Let's go ahead and do the remainder of the non-inmates, and then we'll come back. Bruce Pels, P-E-L-S, LLS.
Judge, this is 22 CF 1370. Mr. Pels has been charged by information with possession of a controlled substance and possession of paraphernalia. Currently is not represented by an attorney, but I did convey an offer to him that Mr. Pels has indicated he wishes to accept. He's also signed and reviewed the plea form, and if I may announce the terms.
You may.
Mr. Pels has indicated that he wishes to accept the state's offer with a dismissal of count 1, pleading as charged to count 2. That will come with a withhold of adjudication, credit time served, court costs, costs of prosecution, and 180 days to pay his court costs. And there is no score sheets since this is a misdemeanor. May I approach?
You may. Mr. Mr. Pels, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay, I'm reviewing the plea and sentencing agreement. It looks like it's got your signature at the end. Is that your signature?
Yes, sir.
Have you gone over this plea and sentencing? I know you're not a lawyer. Have you gone over this plea and sentencing agreement?
Yes.
And do you believe you have sufficient information and knowledge that you can consider the plea agreement and make sure that you're being covered, so to speak, that you have your enough
Yes, sir.
knowledge of the legal goings-on?
I do.
Okay, so you understand that by entering this, you're waiving considerable number of rights, the right to go to a trial, the right to contest it, the right to have the state prove. You limit your ability to appeal this. Okay, do you understand all that?
I do.
Okay, and why are you entering this plea agreement?
To take care of my family, to have to worry about anything else. 60-plus hours a week, every week.
Okay. And do you have any questions concerning this?
No, sir.
Let me say one other thing to you. As the state mentioned, you don't have an attorney.
Right.
Would have no problem appointing you an attorney, letting you go over this with your attorney if you deem that helpful to you. Are you comfortable going forward without an attorney?
I am. I have spoken to one already, and yes, I'm comfortable with this situation.
Okay, very good. Based upon your testimony, the court will accept the plea and sentencing agreement, and there'll be dismissal of count 1 by the state. You'll get a withhold plea, no contest as to count 2. You'll get credit for time served, and then there'll be some fees and costs that are required to be paid within 180 days. After that, it would go to collection. Okay? Very good. Any questions?
None at all.
Okay, thank you very much.
Thank you, Your Honor.
Jim Simoneau, if I pronounced it, did I pronounce that right? Simoneau, close. State, please. Oh, I'm sorry, you got defense here.
He does, Judge. Charles Russell, Public Defender's Office. Judge, this is Jim Simoneau. Case number is 22 CF 1356. At this time, we're going to enter a plea of not guilty. The state filed an information, request jury trial in 15 days following pre-arraignment motions.
Court will enter the not guilty plea, come back on pretrial August 22nd. Stay in contact with your attorney. Okay. Jamie Taylor. Jamie Taylor.
Judge, this is 22 CF 1262. Amy Taylor?
(22 CF 1262), right?
Yes.
Your file on her. Jamie Taylor? I don't get a response, Judge. Madam Clerk, was she sent a notice? Because it seems like we got a lot of failures to appear. Oh, it's a he? Okay, sorry.
Your Honor, it looks like one went to their bond.
Bondsman, too? Okay.
Judge,
Court will issue a capias, no bond. Brittany Watley.
Charles Russell, Public Defender's Office. This is Ms. Watley, Judge. Case number is 22 CF 733. State has filed an information, so we're going to enter a plea of not guilty, request trial by jury in 15 days to file any pre-arraignment motions.
Very good. The court will enter the not guilty plea. We'll come back for pretrial 8/22 at 9 a.m. Okay. We'll start from the top with with inmates. Go ahead.
Okay, I was just
Okay, Mr. Atkinson is here. I conveyed an offer that he's interested in. I'm writing it out. I'm going to give him the opportunity to review it.
Okay, when you're ready, just take your time. We've got a few other cases that, what was the case Chase Hunter, Chase Stewart?
Chase Stewart.
Chase Stewart is here. Would you like to deal with that first?
I would like to see him, Your Honor, to verify.
You want to see, well, let's just bring him out. Chase Stewart.
If I can verify if it's the same
Sure,
person.
I understand. He actually has several charges, so. Well, Chase, no, he's got one. Several Stewarts. We're getting Chase up. Chase Stewart. Yeah, I'm sorry. No, it's out of order. Chase Stewart, there's 3 Stewarts. There are 3 different Stewarts. Chase Stewart. Want to make sure.
Charles Russell, Public Defender's Office. Judge, this is Chase Stewart, case numbers 22 CF 1397. At this time, we're going to enter a plea if not guilty, request trial by jury in 15 days to file any pre-arraignment motions.
And he was represented and was represented, I guess, continued by ORCC.
My meds got discontinued. I couldn't get my meds delivered to me. And I just held on as long as I could, and then I ended up losing my glasses and losing my way to get to where I was in my meetings at the courthouse in Crestview. And
Chase,
do you currently
there's a
represent him?
friend of mine named Jennifer. Jennifer Flowers. And she's going to come.
We can still enter a not guilty. It doesn't matter. It's not going to prejudice him in any way. I wouldn't prejudice him.
And I can look and see if there's a pending conflict, Judge, and if there is, we'll withdraw, but
Yep,
I'll look
Judge
at that.
Flowers'
I'll make a
daughter,
note of it.
But Judge Flowers isn't judging.
Okay.
So she's going to.
So what we're going to do, we'll go ahead.
Okay.
We're going to enter a not guilty.
What's my bond?
You don't have a bond right now.
Bond, it said I had a $21,000 bond. Yes, sir.
Let's listen to Judge Ketchum.
It'll be a not guilty. We're going to come back on pretrial at an 8:22. Hold on a second. Let's see.
Okay, I'll try.
Do you have somebody?
Well,
Or are
I'd
you
like to
living
live
on
with-
your own?
I'm kind of living on my own. I'd like to live with my uncle and try to go back to work if possible. I need to get on my meds.
Yeah.
I don't know why they just discontinued them like that. They said I have to have a Zoom meeting, but I couldn't get the Zoom meeting to work on the cell phone because I'm not real good at it.
I know. I'll talk to Jennifer for you, okay?
Yes, ma'am.
She'll come out and see you.
Okay. Why don't we go ahead, we'll just enter the not guilty plea today, then we'll order him back on 8/22, okay?
All right, God bless
Okay.
y'all.
What's that? 8/24.
Oh, sorry. Yeah, 824.
Okay, yeah, 8/24. Would defense and ORCC in the state come forward just for a second? Okay. Starting kind of from the top on the inmates, is that, we need to do the inmates now, we're good? Okay, we'll start with Mr. Marky Allen. Marky? Marky Bay. Okay. The state announce, please.
Yes, Your Honor. This is Marky Bay Allen, 22 CF 1334. He is before the court on possession of a controlled substance. There was also an indication in the police report that he may have a warrant pending somewhere else. They had charged him with fugitive from justice, but at this time, we just want to see what, if anything, is being done by another jurisdiction before we decide to pursue on that particular count.
Well, first of all, Mr. Allen, the first order of business, you have a right to an attorney. You wish to have an attorney appointed? No? You don't want an attorney?
I wish to appear pro se,
You wish to appear pro se?
because I'd rather speak my mind. I understand that y'all have legal terminology. I just rather be clear and direct about every situation. I'm an honorable man. I have nothing to hide from anyone. I stand on my values and my rights as an American citizen, and I choose to execute that. And I serve my country honorably as well.
Okay.
if I may inquire, is there a hold on him? No.
So it's lifted?
No, it's just, you still got charges here.
Right, right.
Okay.
Well, Your Honor, if the court's so inclined, I would like to convey an offer to him. The offer at this time would be, since you've been in since 5/19, it would be credit for time served, court cost, and it would be an adjudication withheld. You would have a felony record, however, you would not be a convicted felon.
I understand. I accept it.
You accept it?
Yes, sir.
Okay. Let me ask you just a few questions. Would you raise your right hand? Let me swear you in. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Well, as we stated, but I'm stating for the record, as we're recording you, you have turned down the offer of an attorney.
Correct.
And you're indicating you're wanting to accept the offer by the state. You have a right to do that.
Yes.
Just want to make sure that you have a good understanding, you feel comfortable, that you understand the legalities of this. You heard the plea offer from the state, and that's what you want to do?
Sir.
Okay, you understand that she mentioned to you that, you would have a record, a felony record.
But it's
That's
not
significant, so do you understand the legal ramification of that sufficient? I mean, you feel like you understand what you're
full circle, Your Honor.
what you're getting? Okay. And you are clear in your mind that you don't want to talk with an attorney, have any consideration of that? You just want to straight up accept the state's offer?
Absolutely.
Okay. And you understand that by accepting this offer, you're waiving some valuable legal rights.
Understand.
And those legal rights are the right to go to a hearing, to contest this, the right, in most situations, to appeal it.
Now, interject for a second.
Yeah.
Like I said, I'm a man of honor. I accept all things with
Well,
integrity.
you're a man of honor, and I take you at your word for that, but as a man of honor, you still
Have a right.
whether you're a man of honor, or quite frankly, even if you're not a man of honor, you have certain rights as a U.S. citizen.
I understand.
And it's my job to make sure that those rights are protected. That's the whole purpose of me asking. It's not for me to try and trick you or anything. I just want to make sure that you do. You don't inadvertently, I don't want you to go back, something happened and go, if I'd have just realized that record would make me not be able to get a job. If I had known that, I would have done something else. That's what I'm trying to do.
Sir, I seriously appreciate it. I'm not trying to make it seem that way.
Okay.
It's
No.
I stand up on, if I done something with integrity or if I didn't.
Okay.
That's all.
Sounds good. So, go ahead.
This is your score sheet, so only thing I show is a
Okay.
Okay. So your total points are 16.2.
I don't know what that means.
So once you reach 44 points,
Okay.
okay?
You don't
But
score
I've never
prison.
had a DUI in Florida.
I didn't say it was Florida, that's the only thing I can find
Oh,
for
it
you.
goes with it. I got you. Okay.
Now, so, do we need to, are you doing a plea agreement?
Yes, Your Honor.
Okay.
You would just sign it here. and
So
then
they
you-
release me today?
Huh?
I'll be released after this?
On you for somewhere else, that's right.
Hey, no. Not that I know of. I don't do, I swear, I be minding my business. I just graduated college 2 years ago,
That's good.
MBA.
You may. Okay, Mr. Allen. So I'm looking at your plea and sentencing agreement, and you get credit for time served. That means you're not going to be on probation, you're not going to serve any more time, you'll be able to get out
probably today. You do have some of these $615 in court costs
No
that are
problem.
payable in 180 days, or it goes to judgment. You understand that? I see you signed the bottom of this thing. Do you have any questions regarding this plea and sentencing agreement that you want to
No,
bring
Your
up
Honor.
to the court? Okay. Court will accept your plea agreement and sentence you to credit for time served, and the fees and costs will be payable in 180 days, or else it'll be reduced to judgment.
Yes, sir. Thank you.
Thank you. Good luck. Wendy Boardman.
Casey Etheridge for Wendy Boardman. We're here in 2022 CF 1407. If I could just have one moment, Your Honor. She would like to withdraw her, well, I guess. No. Oh. She would like to enter, I'm sorry, I guess we haven't tendered a plea of not guilty yet in this case. She would like to enter a plea of no contest and accept the state's offer. So it would be count one, adjudication of guilt, 12 months of community control, followed by 12 months of probation. Cost supervision waived, $515 in court costs, $100 cost of prosecution, $150 public defender fees, a substance abuse evaluation, any recommended treatment, no possession or consumption of alcohol or controlled substances without a prescription, no contact with Wesley Jones.
Which is who?
That's the victim in this case.
Okay.
No trespassing at 577 Ryan Road, and restitution to Wesley Jones in the amount of $160.
Okay.
Count two, adjudication of guilt, 12 months of community control, followed by 12 months of probation concurrent with count one. And then count three, adjudication of guilt, credit for time served.
Okay.
The state in agreement with that?
Yes, Your Honor.
Boardman, would you raise your right hand? Please ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you've had an opportunity to discuss the plea offer with your attorney, and you feel like you understand what the plea?
A little bit. I mean, I'm a little confused on the burglary part.
Okay, well, that, if you're.
I did have possession of the controlled
Okay,
substance.
hold on. I just want to make sure you've reviewed. You're telling me exactly why we have these questions. I want to make sure you understand. You need to ask your attorney about that. Do you want to take a
Yes.
couple minutes?
Yes.
Ms. Etheridge?
Yes.
We'll hold her over today. I mean,
That's
talk
fine.
with her a little
Okay.
more. I want to make sure you understand what you're doing here. We're not trying to rush you into something.
I'm a little confused on the first two charges, but
Okay.
I'll talk with her.
Can you?
Okay.
Here, I'm gonna give her back, there's no staples, and then she can look
Okay.
at it, and I'll come talk to you about it.
Okay, where'd I go?
This
Okay.
way.
Okay. Jamie Calhoun.
Casey Etheridge for Jamie Calhoun. And Your Honor, we'd be asking to put this on we're entering a plea of not guilty for today and ask to put this on the pretrial conference docket. We have a doctor coming out to see her.
Okay, so we'll come out, put this on a pretrial of 8/22.
Yep.
24, thank you. August 24th, if you all need any date earlier, just let me know, we'll get it on the docket. If there's anything else.
Thank you.
Judge, can I jump in with
Sure.
Hunter Nichols? He's in the audience.
Okay, hold on. We'll do Nichols next, you can come forward.
22 CF 1369.
Very good.
Judge, Mr. Nichols has been charged by information with possession of a controlled substance, paraphernalia, failure to have insurance coverage, and no vehicle registration. He does not have an attorney, but I have conveyed an offer to him that he's indicated to me he wishes to accept, and that offer is as follows. He would be pleading no contest to all of the charges. He would be, the adjudication would be withheld. He would receive credit for time served, $100 cost of prosecution, 515 court costs, and he would have 180 days to pay. I do have a score sheet if I may approach.
Okay, Mr. Nichols, would you please raise your right hand? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
First thing, I'm going to be asking you some questions about what this means to you legally. You understand at the outset you have a right to an attorney.
Yes, Your Honor.
If you're glad to appoint an attorney, you can go over this same thing with him. It's not that you're going to come up with anything less if you accept an appointment, but I want to make sure that you're turning down the appointment of an attorney before we move forward.
Yes, Your Honor.
I feel like you know enough about what's going on with this plea agreement, even as a non-lawyer, to make
Yes,
sure
Your
that
Honor.
you're not giving up any of your rights or you're being treated fairly.
Yes, Your Honor.
So I see you've signed this plea and sentencing agreement, and it reflects what the state just said is the terms. Pretty straightforward. You're playing no contest. No contest, kind of like a half-brother to a guilty plea, generally means that you believe the state can prove their case. Is that why you're doing that here?
Yes, Your Honor, and also I kind of just want to get it over with, so.
Yep, that'll do that. So, but by pleading no contest, it ends up, you gotta withhold, have a record, you got some fees and costs, you aren't gonna have to serve any more jail time, you get credit for time served, no more probation on these charges. Okay, but there are some fees and costs, you have 180 days to pay, and it goes to collections after that. Is that your understanding?
Yes, Your Honor.
You believe it's in your best interest to go ahead and do this now and not try and do a better deal, maybe get a lawyer and they might agree to drop one of the things, who knows?
No, I do believe this is in my best interest.
Okay. You believe you feel like you have enough understanding of the legal ramifications? Were you able to read the plea and sentencing agreement?
Yes, Your Honor.
You feel like you generally understood what it means?
Yes, Your Honor.
Okay. Based upon that, the court will accept your plea and no contest on all counts. All four counts will have withhold of adjudication, credit for time served, and then there'll be court cost and fees of $615, have 180 days to pay. If not, it goes to collections. Any questions?
No, Your Honor.
Okay, thank you very much. Forget which one. Okay, according to my list, we're here on Gwendolyn Cusimano. Which one do we have? What do you have? Okay, I've got Cameron. You don't have Cusimano and Demons? Previously? Okay. That's why. Go ahead and bring out Doris then.
CF Ridgeford, Cameron Doris, and we're here in 2022 CF 1396, and we'd be entering a plea of not guilty for today and asking to set this on the pretrial conference date.
Very good. The court will enter a not guilty plea here today. The court will order defendant back on pretrial August 22nd, August 24th, excuse me, at 9 a.m.
Your Honor, this is Cameron Levi Doris, correct?
This is Cameron Levi Doris.
Defense considering getting a mental health evaluation?
It's already pending.
Okay,
We're
good.
waiting, yep.
Good.
Okay.
Yeah.
Very good, thank you.
Yeah, and there's a bond hearing as well.
Okay. When is the bond hearing?
July 28th.
Okay, next up is Cordarius Grant.
Other institution.
What's that?
Not in our county jail. He's in another.
He's not here. He's in another, where is he at? Walton? So what do we need? This is an ORCC?
Actually, now Marty Nopes just got appointed yesterday.
Okay,
There's also no information.
okay, thank you, Madam Clerk. No information filed yet?
That's correct, Judge.
Okay, so why don't we just go ahead and continue this to the next arraignment until, when's our next arraignment? Next, can you do?
Set it for the one after the 7th?
What's
This
the
will
one after
likely
this?
be going, I don't know if it'll be transferred to the south end.
Okay, so we'll do it on the 28th
Sure, thank you.
of July at 1:30, so it'll be in the afternoon, same arraignment. So we'll continue the arraignment. With the, just note that the information's not been filed. Okay. Who do we have here? Hutto? Very good. Gregory Kane Hutto.
One moment, Your Honor.
No, he still scored prison. No.
Your Honor, we'd like to, we're here with Mr. Huda, right? Yep. A 2022 CF 125, I believe it's a 0. And we're here on this case. We'd like to enter a not guilty plea for today and set it for the next docket day.
Very good. Enter not guilty, come back on pretrial August 24th,
I know.
9
yeah.
a.m.
I'll come talk to you. Yeah, we'll see what we
Ryan
can do.
James.
Okay.
That's it?
Yep.
James, yeah, Ryan James. The state announced pro se.
Ron James. Your Honor, before the court is Ryan James on 22 CF 1365. He's charged with domestic battery by strangulation, possession of controlled substance, more than 20 grams of cannabis, possession of a controlled substance, and count 4, trafficking in amphetamine and/or methamphetamines. And he also has 22 CF 1431. He is charged with trafficking in methamphetamines, possession of drug paraphernalia, resisting without violence, possession of controlled substance under 20 grams of cannabis, possession of a controlled substance ×2, willful violation of pretrial release, and driving while license suspended.
That last case, 22 CF 1431, I do not have on my docket.
Your Honor, I'd done it early. I apologize. That is set for arraignment for 7/7.
Has the information been filed?
That's correct, Your Honor.
So so we can handle both of them.
Yes.
So let's start off with fundamental. Mr. James, you do have a right to an attorney with these charges. You wish to have an attorney appointed?
Yes, sir.
Okay. So the court will appoint the public defender in both counts. And does the,
We'd enter a plea of not guilty for today, but we probably, we've already started withdrawing from one case. I imagine we'll be withdrawing from both.
on this one? Okay. Well, we'll got to find out exactly who is what. Okay, so we'll come back on pretrial 8/24 at 9 a.m. Okay?
Yep, thank you.
Knowles, Catherine Knowles.
Your Honor, Casey Etheridge for Catherine Knowles. And can I pass this one so I can go speak with her? We have an offer in her case that I'd like to talk with her about.
Yes, you can.
Thank you.
We're going to pass and we're going to come back so she can talk to you a little bit, okay?
Thank you, sir.
Okay, thank you. Vicente Martinez.
May I give you this? My medical under there. Okay. Thank you. Yes, ma'am.
We'll bring you back just a little bit, okay? Vicente Martinez.
22 CF 1379.
Did you want to call Catherine Lott? Because she was the one that we thought was out of jail and she's in jail?
Not here yet.
Oh, okay.
Thank you, right.
On Mr. Martinez's case, Judge, information has been filed. At this time, we're going to enter a plea of not guilty, request trial by jury in 15 days to file any pre-arraignment motions.
Very good. The court will enter the not guilty plea and we'll come back on pretrial 8/24 at 9 a.m.
I'll be in touch.
Thank you very much.
Robert Macari. Macari.
Charles Russell Public Defender's Office, Judge, this is Robert Macri. Case number is 22 CF 1319. At this time, state's filing information. We're going to enter a plea of not guilty, request trial by jury, 15 days to file any pre-arraignment motions. And also for the court's information, Mr. Macri has been observing mental health court. I don't know if that's going to be a resolution or not, but
Okay.
for now, we just want to put it off for the 8/24 pretrial conference
Very
date.
good. We'll come back on the pretrial on August 24th at 9 a.m.
Be in touch.
Lawrence Moore, have you got?
CF 1467.
Charles Russell Public Defender's Office, if I could have a moment, Judge?
You may.
Here you go, sign. Oops, I'm sorry. Right there. Judge, on Mr. Moore's case, 22 CF 1467, the state has filed an information, so for procedural purposes, we'll go ahead and enter a plea of not guilty, but we do have a resolution of the case. In exchange for a plea of no contest to the charges, the state's recommending an adjudication of guilt on count 4, which is a second-degree misdemeanor. It would just be time served, but on counts 1 through 3, it would be 180 days county jail concurrent, credit for any time served. He would have to pay court costs, $100 cost of prosecution, $150 public defender fee, and he would have 120 days after release to pay, or the money would go to collections. And I have a score sheet if I may approach.
You may.
That is the state's agreement, Judge.
Okay, thank you. Okay. Mr. Moore, let me just ask you a few questions, make sure you understand kind of what's going on with this, okay, from a legal standpoint. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement. Is that your understanding? Are you in agreement with that?
Yes, sir.
So, and I also see you've put your signature on the plea and sentencing agreement. Did you go over this with your attorney, make sure and ask all your legal questions you have of this? Because this does impact you legally, even though you're entering into a plea agreement that, I mean, it's going to entail, obviously, some county jail time, et cetera, and other legal rights. Have you been able to go over it with your attorney, make sure you understand kind of all that it affects you legally? You understand that you're waiving the right to go to a trial, you're waiving the right to contest this, it limits your right to go to file an appeal. Do you understand? Did you get all those kind of questions answered of your
Yes,
attorney?
sir.
And you feel like that this is in your best interest?
Yes, sir.
Why?
That's just the only one deal y'all came with, besides the letter I wrote y'all where I wanted to take 6 months rehab and probation if it was possible, but he said this what y'all came with, so I gotta settle with what y'all came with.
You can all, now, you don't always have to do it. You can say, no, we'll go to trial on this.
And I don't want, but I just rather take it as is. If I can't get what I want, I might well take what y'all give me.
Okay, you believe it's in your best interest to
Yes,
enter
sir.
into this? Okay. Defense is in agreement on the score sheet?
Yes, Your Honor.
Okay, very good. Based upon that testimony, the court will accept your plea. No contest, be an adjudication of guilt on all counts. On count number 4, which is the petty theft, you get credit for time served. Counts 1 through 3, they'll all be served at the same time, but you have separate 180 days in the county jail. They'll all run concurrent. In other words, they won't stack on top of each other. They'll all run, so it's basically a total of 180. Minus whatever you've had credit for time served. That always is a part of it. In addition, you got court costs and fees that will be due as contained in this plea and sentencing agreement 120 days after the release, or it goes to collections. Okay? Is that your understanding?
Yes, sir.
Do you have any questions regarding either the agreement or anything else relating to this plea agreement? Okay, very good. Court will accept your plea agreement and sentence you on counts 1 through 3 to 180 days in jail, county jail, credit for time served, and the fees and costs payable, 120 days. Thank you very much.
Yeah, facts and everything that you got on, mail everything you got to me, to the jail.
With the plea agreement?
Richard Nunez?
Charles Russell, Public Defender's Office. Judge, this is Mr. Nunez, case number 22 CF 1355. State's filed an information rendering a plea of not guilty at this time. Request trial by jury, 15 days to file any pre-arraignment motions.
Very good. The court will enter the not guilty, come back at pretrial on August 24th at 9 a.m.
Yes, sir.
Okay?
God bless you, Your Honor.
Thank you.
Can I give you quick information?
Nathaniel Parker.
I got your letters. Judge, Nathaniel Parker, 22 CF 1471, we dealt with that yesterday. That's the one that didn't have any information yet. He had another case that's set for 7-7, so we put both of the new cases to 7-7.
Very good. Stacy Reeves.
Judge, could I pass her for a moment? I have a plea offer, and I'd like to go back.
Okay. Can we bring out Lorraine Short? We're passing over Reeves so he can talk to him. Her.
He said that.
Would the state announce on this because it
Silly.
is, she's pro se. Lorraine Short, case number 22 CF 1255. Hold on just a second, ma'am.
And Your Honor, we're showing that this is a case where there is a.
Out-of-state fugitive.
Correct, Your Honor. And we would like to inquire whether Ms. Short would like to waive extradition or not.
Short.
I don't really understand what that means. I mean, I don't know the process of extradition or anything. I don't have an attorney.
Would you like for an attorney to represent you so you
You
can
want me
ask
to
some questions?
appoint you an attorney so you can talk to him, your attorney, about what this means? Yes?
Sure.
Okay, court will do that. Court's going to appoint the public defender. I'm going to give you a few minutes, so maybe you can.
sign for extradition. We can go ahead and go with the governor's warrant, please.
So what do we do here today?
I guess set a control date, Judge.
Yes, Your Honor.
How far out?
60 days would be fine, Your Honor.
Okay, so we come back on another miscellaneous or a?
That's fine, Your Honor.
Okay, so we'll come back on, the August 25th, is that too soon, or?
That's fine, Your Honor.
September 29th, that'd be 90 days.
August 25th would be fine, Your Honor.
August 25th. we'll
I'll
come
go
back.
ahead and sign for extradition.
What's that?
I'm gonna go ahead and sign.
You sure? Your choice.
I mean, how long can you hold me if I don't? Just asking.
Till it takes for them to get the
You can hold me.
We could always put this on for 7/7 and give her an opportunity to have some conversations and decide what she wants to do.
Would that be better, Mr. Russell? Just come back in a week and kind of, so you have a chance to chat with your attorney, make sure you're comfortable with this. We're not trying to coerce you to do anything, ma'am. This is your choice.
Okay, yeah, that's fine. That'll
Sorry,
work.
that'd be good?
Mm-hmm.
Okay. We'll come back then on 7/7.
Come on, this is-
Okay, thanks.
Will we do it in the morning or in the afternoon? Okay, that's fine. That's 7/7, we can do it? Okay. At 1:30. 7/7 at 1:30. Okay. Stewart? Hunter Stewart, right? Okay.
Charles Russell, Public Defender's Office, case number is 22 CF 1489. State's filed an information, so at this time, we're going to enter plea of not guilty, request trial by jury, 15 days to file any pre-arraignment motions.
Court will accept the not guilty plea. The court will order him back on pretrial August 24 at 9 a.m., okay? Tristan Stewart.
Charles Russell, Public Defender's Office, Judge, he has two cases. The only case on the docket right now is 22 CF 1297, but he also has a violation of probation in case number 18 CF 977. If I could have a moment, Judge? Judge, Mr. Stewart is charged in his new case, 22 CF 1297, with possession of a firearm by a felon with actual possession, which would trigger a 3-year minimum mandatory. The state has offered him, if he will admit to violation of probation in 18 CF 977, and then in 22 CF 1297, on count 1, he would plead to a lesser included possession of a firearm by a felon, but it would be constructive, and then plead to count 2 in the new case as charged. The state is recommending revoke and terminate his probation in the 2018 case. He would be adjudicated guilty on all counts, sentenced to 11 months, 29 days in the county jail, all cases and counts concurrent, but he would only receive credit since his most recent arrest. He would be assessed court costs in case number 22 CF 1297, $100 cost of prosecution in each case, $150 public defender fee in 18 CF 977, and $100 PD fee in 22 CF 1297. I have 90 days after release to pay, but I'm going to change that to 120 to give him a little bit more time. And I have a score sheet if I may approach, Judge.
You may. Thank you.
That's the state's agreement, Your Honor.
Council approach. You understand what's going on here. Would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and the core of which is, the 2 counts with 11 months, 29 days in the county jail, and then there's fees and costs, et cetera. Have you gone over this plea agreement with your attorney, and do you feel like you understand it?
Yes, sir.
I see you've signed the back of it. You had all your legal questions answered about your plea agreement.
Yes, sir.
And not insignificantly, are you aware of what the maximums are on these 3 charges? What are they?
About 15, and then 1.
Okay, so a total of 31.
31 years, yes, sir.
Okay, so you're getting 1129. So I certainly understand why you're taking this plea. But I just want to make sure that you're aware of the legal issues here, and you understand that by entering into this plea, you're waiving the right to go to a trial,
Yes, sir.
you're actually limiting your ability to be able to file an appeal on this. Have you had all your legal questions answered
Yes, sir.
by your attorney? Feel like you've gotten good representation?
Yes, sir.
Very good. Based upon all that testimony, court will accept your plea as contained in your plea and sentencing agreement, and will sentence you to, on the 2 primary charges, 1129 in the county jail, revoke and terminate probation. There'll be a number of fees and costs that must be paid within 120 days after release, or it goes to collections. Okay? Any questions?
Concurrent, Judge.
Concurrent. If I did not
Ready.
say it, it's the prison sentence, or not prison, the jail sentences are definitely concurrent. They're not stacked on top of one another. Thank you for that clarification. Sorry.
Thank you, Judge.
Okay. Yeah. Mr. Bielik. That's who. This is a case from this morning.
Yes, Your
Ms.
Honor.
This is your case.
Yeah, Casey Etheridge for Mr. Bulick, and we're here in 2021 CF 876, 2021 CF 403. And Your Honor, we would be denying the allegations for today and asking to set it on the 7/28. There's a new law violation that I don't believe he's even been arraigned on, it's set for 7/7. Looks like an information's been filed. I mean, if we could we set them all on 8/22, Your Honor, and
Well, I mean, if the information been filed, you can enter
we enter a plea of not guilty on the,
what's the new law charge number?
it's 2022 CF 1477.
Okay.
And his only violation on these probations is the new law case. If we could just go ahead and set all of them for the
So we'll set,
8/22.
yeah, we'll enter a not guilty plea on 22 CF 1477, and then that case plus the two on today's case, we will all reset to our regular pretrial day of 8/22 at 9 a.m. In the meantime, meet up with your attorney, okay?
Yes, sir.
Okay. Very good, thank you. Okay. So we've got a few others. Do you want me to take a break and then, or you want to?
I do have one that's out of custody who I did wish to accept the state's offer, and he is ready at this time.
Okay, and Mr. Harper, any of the ones that you've got?
No, Your Honor, I just have a quick continuance on a hearing.
For today? Oh, for after this? You want to take that first?
I can wait for Mr.
Okay. One of the ones at 2 o'clock?
Yes, sir.
Okay. Go ahead.
This is Jared Atkinson. He's before the court on 22 CF 1394. He is agreed to accept the state's offer, which calls for 2 years of probation, no contact with the victim, $415 in court costs, $100 in cost of prosecution, and it reserved the right for a restitution hearing, and it'll have within 120 days. If you can make sure you give all the current
Yes, ma'am.
information so we can send you notice.
Is he already signed?
Yes, he has, Your Honor, and I did provide him a copy.
Okay. So I'm going to go ahead and swear you in. Would you please raise your right hand? Do you
Yes.
swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. So, the state attorney showed you the score sheet, correct?
Yes, sir.
Did she explain it to you just a little bit?
Yes, sir.
Kind of the bottom line? You know what the bottom, what's the bottom line?
No more messing up.
Well, you know what the bottom line is on the score sheet? This is the lowest, if you convicted, this would be the lowest that would be within the
Right.
within the range that I'm supposed to go in. I can go a little higher. But
Yes,
that's
sir.
your range. So that's basically a floor, a minimum, 18 months. So this is actually technically a downward departure? And
Yes, sir.
on
This-
what base? We have to have a
This is-
specific reason to do it, so.
It's a legitimate negotiated plea, Your Honor.
So, you heard the attorney state the terms of it. Obviously, the core here is 2 years of probation, no contact. Is the victim like the pawnbroker or whatever?
Actually, the victim that I'm referring to would be his uncle, Zachary Atkinson.
Okay, and how is he the victim of It doesn't matter.
It's a big bunch of
Don't worry
mess,
about it. Don't
sir.
worry about it. I don't need to know. As long as you're in agreement with the no contact and you're aware, probably need to write in the name of the victim, which I'm going to ask you to do in just a second. One thing, there are some fees and costs that you are required to pay during the probation. Now, there is a reservation on restitution. I want to make sure you understand. You know what that means?
Yes, sir.
What does that mean?
We're gonna have a hearing on the, with the items, I'm assuming.
Means maybe.
Yes, sir.
Okay, so it's a reserve, basically, we're putting that aside. If the
Okay.
state
Mhm.
wants you to have restitution and wants to claim restitution.
Yes, sir.
They got to file something.
Okay.
At that point, you can argue, no, it shouldn't be there. So, but right now, we're just moving it aside. We're
Sounds
not
good.
dealing with, we're not resolving that issue. But it says reserve restitution for 120 days. So if
Yes.
they don't do something in 120 days, it goes away.
I understand it.
So they got to do it in 120 days. If they do, you can fight it.
I understand.
So you've had a chance to, I see you signed this plea and sentencing agreement. Did you?
Yes,
sure
sir.
You read it closely, didn't you?
Yeah, yes, sir. I kind of want the probation. I told her, I said, if I can't do probation, I don't even need to be out. I don't need to be free. You know, I've made a lot of changes, and there's a big bunch of mess up there on the farm, but that's family issues, and I believe this is God's will, and you know, I'm ready to get on with it and get on with the rest of our life. Everybody go back to regular business.
You gonna sign this document for me? You might want to get the defendant to sign it too.
I missed one. I missed one.
That's all right. That's all right. I'll get it.
You will sign here, and I'll sign at the bottom.
Okay, thank you. So again, seeing you've signed this back of this, feel like you understand the terms in this plea and sentencing agreement, there's a lot of legal stuff in there, you feel comfortable, you understand what you're reading here?
Yes, sir.
One thing I want you to understand, is this an adjudication? One thing it doesn't on here. No, huh?
Adjudication?
Yes, sir.
Okay, it does say adjudication of guilt. Okay, that's important.
Yes, sir.
Because I've seen this ain't your first rodeo. I'm not trying to jump on you, I'm just trying to
There'll be
say.
no more.
The reason why it's important is that the way, as you know,
Yes, sir.
the criminal justice system is cumulative. And these are pretty, even though you're getting a pretty good deal, these are pretty serious, well, they're not pretty, these are serious charges.
Yes,
And they're
sir.
added to the other ones.
Yes, sir.
If you get in more
Hey,
trouble
hey.
or you violate this, I mean, you're
Yes,
right on the edge.
I
Okay.
understand everything, and I'm very, yes, sir.
Well, I hope you, I mean,
Hey, we
sometimes
will-
that's all we can do is rely on God, so I'm all for you.
Yes.
But, I know that story about God sending a life raft, on the rising river flow. You heard that story?
Yeah.
You know that story?
Yes, sir.
Sometimes you gotta jump in the boat.
Yes, sir.
Okay?
Sink or
You gotta
swim.
jump in the boat. God's sending you this, God's probably in the form of the probation office,
Yes, sir.
okay?
Yes, sir. We
No,
go.
I'm serious.
I understand. Yes,
Sometimes
sir.
you gotta look and see how God's presenting himself.
Yeah,
Seems that we're on a spiritual discussion here.
Yes, sir. It's time for a change. I've made changes.
Okay.
Hard changes, and this is ridiculous.
Okay. Okay, well, I think you understand what you're doing with this. The court will accept your plea, sentence you to 2 years of probation on both counts. They'll be concurrent. No contact with the victim. The court costs will be paid during the course of the probation. We'll waive the cost of supervision of probation, reserve on restitution for 120 days. Okay? Good luck. The hard
Yes, sir.
work starts
Thank you.
now. Okay. Get off that soapbox. Okay. So do you want to take a break? Do we have any others? You want to do yours, Mr. Harper? Why don't we? Sure, that's all right. I know we've got a couple there.
Judge Rudy Harper on behalf of Mr. Mosley. He's on the afternoon docket at 2
Correct.
o'clock. 16 CF 2013. At this time, I don't think either of the parties are ready to proceed, particularly since my client hasn't been transported from the correctional facility. There is a motion in order. There has been an order to transport him. He just hasn't got here yet, Judge. So we had asked to continue this, and I think we agreed to do 728, if that's okay with the court?
Your Honor, this is Ms. Bosso's case. She had no objection to the continuance and.
I remember we discussed that this morning, and the court's fine with that. I understand we can't proceed without the defendant. So we'll come back on 7/28 in the afternoon, so it'll begin at 2 o'clock.
Yes, sir. Thank you, Judge.
Thank you.
That's all I have this afternoon.
Okay, have a nice day. Ms. Etheridge?
Your Honor, I have several I'm ready on, but I don't know if the court wants a break or.
Yeah, let's take just short break.
Sure.
10 minutes. 10, by the time I walk down there and back, it'll be 10 minutes.
All rise.
But at least we'll know who all says. Yeah.
All rise, court's back in session.
Which one do you want to do?
Okay, let's start with.
You want me to go through my list that I have, or?
We can, Your Honor, or I can just start calling people, it's fine. Nicholas Bennett.
Bennett?
And it's 2022, or 2022 CF 1337.
I know, you got to help me on my,
On the felony plea docket, Judge.
Number 4.
okay, very good.
Okay. Mr. Bennett would like to accept the state's offer and enter a no contest plea. On count 1, it'd be adjudication withheld, credit for time served, $515 in court costs, $100 cost of prosecution, $150 public defender fees. He has 180 days to pay or be reduced to judgment. And then count 2 is adjudication withheld, credit for time served. May I approach?
State?
That's correct, Your Honor.
Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you heard your attorney state the terms of your plea agreement. That's what you're agreeing to?
Yes, Your Honor.
And I see that you've signed the plea and sentencing agreement. It's got your name on it. Have you gone over this? Because it has some other stuff in it about the plea and the fact that you're waiving your rights and other legal issues. Have you gone over this? Make sure you had all your legal questions answered?
Yes, Your Honor.
Obviously, it's a pretty straightforward plea. You're getting credit for time served and then on both your counts and some fees and costs that have to be paid.
Yes, Your Honor.
Is your understanding? You have to be paid within 180 days or reduced to judgment.
Yes, Your Honor.
You realize you're waiving the right to a trial and just a final adjudication. It impacts your ability to appeal, et cetera.
Yes, Your Honor.
Okay, very good. Based upon all that, the court will accept your plea of no contest on the 2 charges. The court will sentence you to credit for time served. Adjudication will be withheld, and you'll have the court costs and fees that are contained in here payable in 180 days or reduced to judgment. Okay, good luck.
And if we could call Amanda Booker.
Amanda Booker.
Yeah. There was a failure to appear, and you issued a KPS already, but she is
I did.
here. She's been here for a while. So-
She was here?
Well, she wasn't here when you called, but she got here not long after.
Oh, okay.
Approaching, Your Honor. This is in 2022 CF 1229. And Your Honor, we'd be entering a plea of not guilty today and asking to set this on the August 22nd pretrial conference date.
Very good. The court will enter a not guilty plea and come back on pretrial August 22nd at 9 a.m.
Okay, thank you.
Okay. I'm be on time on that. I don't want to have you picked up for that, okay, ma'am? You want to did we do Wendy Boardman? That one of the inmates?
Not yet. Yeah, we can do her. That's
Want
fine.
to do it? You wanna- Yep. Ms. Boardman?
Boardman.
Casey Etheridge for Wendy Boardman, and we would like to enter a plea of not guilty today and set this for the next pretrial conference date.
Very good. Court will enter not guilty and we'll come back on 8/24 at 9 a.m.
And for
Okay.
the record, Your Honor, that was a downward departure offer, and it is hereby revoked.
Okay.
Great.
All right. That way.
Terry Cheshire.
You decide what you wanted to do?
Yes, ma'am.
What did you want to do?
Judge Judge, this is
Okay.
22
Yeah,
CF
but,
1230.
Okay.
He
Your Honor,
said give it to Mr. Baker, let me tell him.
may I have one moment, Your Honor?
You may.
Your Honor, Mr. Chesser, we were wondering if Mr. Chesser could enter a plea today and then be sentenced on 7/7 to the state's offer.
It's 10 days jail, Your Honor. I don't have an objection to setting off sentencing to 7/7 if he wants to plead a day. It is the arraignment day, so if the court has availability on the 7th to be remanded basically and sentenced to the 10 days, I have no objection.
Okay. I mean, do we just do it that he'll be remanded on that date, or or do we do everything and then?
I'd rather just go ahead and let him plea and then come back for sentencing if that's possible. That way
Okay.
he's entered a plea.
So he can't back up on the plea, but
Right,
he's,
without good cause. Right, so that way he'll come in for 7/7, he'll be sentenced and remanded from here.
okay,
You hear that?
very good. I need to ask you a few questions. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
What is the plea agreement,
Okay. It's
madam?
count one, adjudication of guilt, 10 days in county jail with credit for any time served, $415 in court costs, $100 cost of prosecution, $150 public defender fees. He'd have 180 days to pay or be reduced to judgment. And count two, adjudication of guilt, credit for time served.
Is that your understanding of
Yeah,
what the plea
yes, sir.
agreement is?
Yes, sir.
And is he signed it?
Yes, he has signed it. Okay.
Is that's the state's agreement?
That's it, Your Honor.
And the score sheet fence is in agreement?
Yes, Your Honor.
Okay, Mr. Chester, you heard your attorney state the terms, have you signed that yet?
Yes, sir.
Okay. Have you had a chance to make sure and inquire of
Yes, sir,
your
I have.
attorney
Yes,
about
sir.
that? I just want to make sure that you understand it.
Yes, sir.
Got
I
all
do.
your legal questions answered? You know you're
Yes, sir, I
waiving the
got-
right to go to a
Had all
trial?
my questions answered, yes, sir.
Okay, you feel like you've gotten good legal representation? You understand
Yes,
what's
sir, I
going
do.
on?
Yes, sir, I do.
Why are you entering into this plea here today?
It's in my best interest, sir.
Okay? That's a good answer.
And Judge, on the score sheet, I have to put the date of the sentence, so if you would like, I can hold on to it until sentencing.
fine.
It's not a downward departure, so we don't need to put anything on the record regarding that, but I will turn it in when we are here for sentencing.
Very good. You do have any further questions of your attorney or the court?
No, sir, Your Honor.
Okay. Based upon your testimony, the court will accept your plea and will resolve to conduct the sentencing on the 7th of July, what time? In the afternoon?
That's fine.
Morning?
It doesn't matter.
Morning,
9 o'clock.
morning's fine
9
with
o'clock.
me.
9
I just
o'clock.
need to come on and get it on
Okay,
over with.
9 o'clock.
Okay.
Sounds good.
All right.
I'm sorry.
Oh,
It's in the afternoon? Okay, so it'll be in the afternoon.
Okay.
7 in the afternoon.
7 in the afternoon.
yeah, so it's 1:30, right, Your Honor?
1:30?
1:30.
1:30.
1:30.
On the 7th.
Yep, on the 7th. Yep.
Fine.
Yep, you can have it.
Thank you, ma'am.
Just have to remind me of this because I know you're going to throw me off and I'm going to be caught up in
Yes, sir.
something else.
And Your Honor, we have Catherine Knowles.
Catherine Knowles.
Casey Etheridge for Catherine Knowles. We're here in 2022 CF 1325. So you gotta accept still. Okay, and she would like to enter a plea of no contest and accept the state's offer. Count one, adjudication of guilt, 15 months of community control, cost of supervision waived, $515 in court costs, $100 cost of prosecution, $150 public defender fees, a substance abuse evaluation, any recommended treatment, no possession or consumption of alcohol or controlled substances without a prescription. Count 2, adjudication of guilt, credit for time served. Count 3, adjudication of guilt, 15 months of community control concurrent with count 1.
Deed agreement.
That's correct, Your Honor. And Your Honor, this is a legitimate uncoerced plea, a downward departure.
Ms. Knowles, I need to ask you a few questions. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state that, you can put your hand down. You heard your attorney state the terms of your plea agreement.
I
Is that
did.
what you're agreeing to?
I do, sir.
Okay, and I see that you've signed the plea and sentencing agreement that also contains those. The key part of the plea agreement is concurrent 15 months of community control.
Yes, sir.
So they'll both run at the same time, total of 15 months. You know, community control, there's a better name, a name I like better than community control. You know what it is? It's called house arrest.
Yes,
Okay, there's a lot of requirements. That means you can't just go out and stay out till curfew. It's house arrest. Do you know what happens when you're on community control and you violate community control? You know what the next step is?
Yes, sir.
What is it?
It would be jail time.
Jail time, maybe DOC time,
Yes, sir.
okay? So I'm just telling you that, I'm not trying to threaten you, I want you to be successful. But ma'am, you better take this serious, these are serious charges. The state actually, we have a range of outcomes that they give the court.
Yes, sir.
The state is going below that to give you this 15 months. They're giving you a deal,
Yes, sir.
okay?
I do, sir.
Okay,
I
so
understand.
you better,
I will.
you gotta take this straight or else, because I really don't want to put you in prison, ma'am. Do you understand that?
Yes, sir.
But if
I
you
do.
come back before on this, could happen. Because all the numbers stack up bad, okay? Okay. Hold on a second, let me just ask you a couple more questions, and
Yes,
I'll
sir.
get off my soapbox. You've got to, do you make sure you understand all the legal language that's in here? Do you have all your legal questions answered, on this plea?
Yes, sir.
And you understand you're waiving the right to go to a trial and to contest this?
I do,
You
sir.
believe this is in your best interest?
I do, sir.
Okay. Is part of that because of what you score and the total number of the maximum incarceration you could have? Is that one of the reasons?
Yes, sir, it is.
Okay. Do you have any further questions of your attorney or of the court?
Just one, sir.
Okay.
I have a court date on the 5th of this month.
Or what?
Driving, I was in the hospital, Art did not
We don't want-
No,
automatically.
just,
We
don't
talk
talk
the
about it, just tell me what it is.
Yes, sir.
It's
he
a
was
traffic
driving without a
ticket?
driver's license, sir, not once but twice. And I'll go to court on that on the 5th. And I-
Were you all aware of
I
this?
just don't want it to take this away.
This won't take this away, but
She just has to provide that information to her community control officer, and that they make arrangements. She has to write out a schedule.
Down here?
Yes, sir.
Down here?
Yes,
Oh,
sir.
yeah, we'll make sure she gets it. Or, we're not gonna take her, but we'll certainly allow her to go.
yeah, but my point is though, that first of all, she's not gonna get violated for those new, because, but is that gonna, shouldn't we try and kind of wrap it all up in one, or is she gonna,
I would love to.
I don't know, I'm just,
Yes, yes, ma'am. Yes, ma'am, on
I don't know
Industrial
how to,
Boulevard.
I don't wanna open a can of worms there. We'll just go with what this is.
Okay.
You all can deal with it if you need to do anything further. Okay. So this will not affect this thing. But now, we don't know what they're doing with it, but this won't affect this plea, okay?
Thank you, sir.
Okay, very
Yes,
good.
sir.
The court's accepting it and again, sentencing you to the 15 months of community control on both counts. The third count, you'll get credit for time served.
Yes, sir.
Thank you very much. Good luck.
Yes, he can, come see us.
They need to get your fingerprints first, and then you come back. So,
And can we pass those papers that I gave you on to them?
Yeah,
I don't
yeah.
have another copy of them.
Yes.
Thank you.
Catherine Lott,
Thank you, sir.
good luck, man.
Not yet.
Charles Russell, Public Defender's Office, Judges Catherine Lott. Case number is 22 CF 1264. State has filed an information. At this time, we're going to enter a plea of not guilty, request trial by jury in 15 days to file any pre-arraignment motions.
Very good. The court will accept the not guilty plea and order the defendant to pretrial on 8/24 at 9 a.m. Okay? Stacy Reeves, is that? Stacy Reeves.
If I might have a moment, Judge.
You may.
Sure, case. Charles Russell, Public Defender's Office, Judge, this is case number 22 CF 1296, which is here for felony plea day. For procedural reasons, we'll go ahead and enter a plea of not guilty. She also has a violation of probation in case number 2016 CF 1720. We've reached a plea agreement with the state to resolve both cases. She's going to admit the violation of probation in the 2016 case, and she's going to plead no contest as charged in the 22 CF 1296 case. The state is recommending that her probation in the 2016 case be revoked and terminated. She will be sentenced, adjudicated guilty on all counts, sentenced to 180 days in the county jail concurrent on all counts. Credit for any time served, be assessed court costs in 22 CF 1296, $100 cost of prosecution in each case, $150 public defender fee in 16 CF 1720, $100 PD fee in case number 22 CF 1296. She would have 120 days after her release to pay, or the money would go to collections. And I have a score sheet, if I may approach.
You may.
State's in agreement.
Thank you. Score sheet, you're in agreement?
Yes, sir.
Okay, Ms. Reeves, I just need to ask you a few questions. Would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, I do.
You heard your attorney state the terms of the plea agreement. Is that what you're agreeing to?
Yes.
Okay, and I see that you've signed the plea and sentencing agreement. Have you been able to go over this plea and sentencing agreement with your attorney?
Yes, I
Make
have.
sure you have all your questions answered, your legal questions, because there's more than just the terms in here. There's a lot of this, such as the fact that you're waiving the right to go to a trial, that this could affect your ability to appeal, things like that.
I
Have
do
you been able to
understand.
get all those legal questions answered?
Yes, I have.
Okay, just want to make sure that, two things. One, you understand what you're doing. Two, that is free and voluntary. That's why I'm asking you these questions. So, the core of this, obviously, is the 180 days in the county jail. You will get credit for time served. So the 180 days is for both counts, is that correct?
For all counts concurrent, Judge.
Okay, they're all counts concerned. So all the possessions, so all 4 of the counts? Okay,
Yes, sir.
very good. So there will be an adjudication of guilt that does have certain repercussions. You understand that?
Yes, sir.
You have a question? Go ahead and ask him.
Did you already ask? No further questions, Your Honor.
Okay. And you do understand that you will get credit for time served, of course. and
Yes.
that's
Yes, I
obviously
do.
an important consideration. Okay, based upon that testimony, the court will accept your plea and adjudicate you guilty on all 4 counts, sentence you to 180 days in the county jail. They will be concurrent, they'll all be run at the same time. You will get credit for time served for these. In addition, there'll be fees and costs that'll be payable 120 days after your release, or it goes to collections.
Yes, sir.
Okay.
Thank you.
Any questions to your attorney or to me?
No.
Thank you very much. Good luck.
Thank you.
Okay. I believe that's all on our arraignment docket. I think we've got just a couple on, not couple, I think we've got 3 or so, 4 on the,
And we have Ms. Walker from this morning, Judge.
we have Walker from this morning.
Chisha
Okay.
Walker, number 36 on your docket. She's the one with, I gave her the agreement before we broke for lunch, and she was going to read it, and then,
Ah, yes.
but whenever you get to it, Judge.
Okay. What number was that? Okay, let's go ahead, we'll go ahead and do that. Walker. Shisha Walker.
Make sure we don't forget it.
Good thing we rode together, so you can't leave without me now.
Charlie, did I give you a score sheet?
Judge, if I could have a moment. Charles Russell Public Defender's Office. Judge, this is Chisha Walker. Case number is 21 at CF 969. Ms. Walker's before the court on a violation of probation. We've reached an agreement with the state in exchange for an admission of the violation of probation. The state is asking for an adjudication of guilt, reinstate to her probation with the original terms and conditions with one modification. If she has a further violation of probation, any witnesses would be allowed to appear by Zoom. She would pay $100 cost of prosecution and a $150 public defender fee. And since she's going back on probation, she can pay all that during her probation. I have a score sheet. May I approach?
May. State?
That's the agreement, Judge.
Okay. And defense is okay with the score sheet?
Yes, sir.
Okay. Ms. Walker, would you please raise your right hand, ma'am? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay, you heard your attorney state the terms of your agreement here and on the violation of probation, that you basically reinstate to probation on the original terms. It's the issue with the Zoom, if you didn't have anything else, anything further, and there'll be some costs and fees that are payable, some additional ones. Do you understand all that?
Yes, do I pay those fees through JPay or?
Yes.
Okay? Okay, yes. Thank you, Mr. Barry. He's the expert on payment of fees.
Yeah, I don't know.
Okay, so I see you've signed the plea and sentencing agreement, It has, if you kind of read through this, make sure you understand. You have the right to contest all this, but you're waiving the right to do that. You want a final resolution of this case?
Yes,
Have you had all your legal questions answered by your attorney?
yes,
Do you have any further legal questions, either of your attorney or of the court?
oh, sir,
You believe this is a fair resolution?
yes, sir.
I happen to agree with you.
Thank you.
Court will accept your plea and adjudication of guilt and reinstate the probation with the original terms and conditions. Only the modification would be to allow witnesses to appear by Zoom for any future violation. And the fees and costs will be added to your payable costs.
Okay.
Okay? Thank you.
Thank you,
Good luck.
Judge.
Okay.
I guess one, but technically two from this morning's docket left.
We have two from this morning's.
We have Mr. Galt back. We got the letter from the victim. It was a bond hearing that we had this morning.
Right?
He has a letter from the victim saying she wants him to come home, so, and the state's seen it, and it's notarized and everything, so hoping we
Okay.
can readdress that.
Let's go.
Your Honor, would you like to review it?
Sure.
Here in 2022 CF 1083, Mr. Ryan Galt.
Okay. Go ahead.
Your Honor, in addition to the testimony this morning, we're just asking that the court has already agreed to remove the no contact provision and instead put a no violent contact provision. And so we're just asking that Mr. Galt be able to go home, reside in the home, and the victim has submitted the statement saying that she wishes that as well.
Well, actually, you need to revise it to allow him to be at the house, around the vehicle,
Okay.
and around the place of business, because that's, even though she doesn't say it in here, that's apparently what she wants.
Yes.
And that's what it will be. Okay? So the responsibility is on you to get this right. Got to figure out some alternatives in this. It's serious stuff. And the problem with these kind of cases, they don't get better. You got to make some changes to figure out how to deal with this, okay? So it's up to you. Obviously, the court, if there's issues in the future, it's probably be harder to resolve it in a positive fashion, okay?
Sure.
You want to file this or just, Madam Clerk, would you just put that in the court file? Okay, anything else we need to do on that?
No, Your Honor.
Okay, good luck.
Yep. Your court date's August 22nd, don't forget. And then the other one from this morning is Anthony Bristol.
Bristol.
Casey Etheridge for Mr. Bristol, and he would like to admit to the allegations in the affidavit and accept the state's offer of adjudication withheld, revoke and terminate probation, 12 months of community control, $100 cost of prosecution, $150 public defender fees, and he has the same original terms and conditions.
Okay, Mr. Bristol, would you raise your right hand? Do you swear? Go ahead and sign that first.
Yes, sir.
You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
Yes, Your Honor.
You heard is the state in agreement on this?
Yes, Your Honor.
You heard your attorney state the terms of the plea agreement. Is that
Yes,
what
sir.
you want to do here today?
Yes, sir.
And have you had a chance, I see you just signed the violation of probation plea agreement. Have you had a chance to make sure you had all your legal questions answered about this? Because this does affect your legal rights. You're waiving the right to go to a trial. It's the final resolution. It affects your ability to appeal, all those things, because you're resolving them here. Have you had all those types of questions and others answered by your attorney?
He's just asking if you have any answers.
Yeah, I mean, no, I mean, I'm okay with it.
Okay, you feel like you understand what's going on? Just
Yes, sir.
want to make sure, there's a lot of
I
legal
appreciate it.
stuff in here, you know?
Yes, sir.
We're trying
I
to,
had COVID before, sir, like that's the only reason why I did. I would have been able to pass the probation and everything, so I have a good feeling I'll be able to take care of this.
okay. Very good.
Yes, sir.
Okay, I'm sorry.
Based on a comment from probation, we would have to, I guess, revoke, reinstate.
Right, he's only on probation till, October.
So we, a new.
Well, it's in
new
there,
term of
revoke and-
It
community
says
law.
revoke and terminate
Yeah,
12 months, is that what we?
yeah.
Yeah, I'm sorry, Judge, that's.
Okay,
So-
so
sorry.
we got,
Am I gonna be able to go home tonight?
You're good, yeah.
you finally trained us up properly.
Yeah, they're working on me, I know.
Okay, so the court will withhold adjudication on the primary charge, the possession charge, revoke and terminate your current probation, and basically start you on 12 months of community control.
Yes, sir.
That's like house arrest,
Yes, sir.
higher supervision. You got to take it serious.
I
Don't
will.
want you to
Yeah,
mess
I will.
up.
I promise I'll take it
Okay.
serious.
So you've got some cost and fees that'll be payable on the term of the probation or the community control, and the same original terms and conditions would apply.
Okay.
Okay,
Yes, sir.
very good. Good luck.
Thank you so much.
Thank you.
Judge, we have David Latham.
David Latham.
Sorry. He was the individual here
I know.
today, Monday. He was here Monday. We did set
You
up
want to
Thursday.
have him come up?
Well,
Is
he's
he
not
here?
here, but there
He's
was
not.
some discussion. I did speak with him because he was having health issues. He was having trouble breathing. So we set him for today, this afternoon, but there was some discussion. Was Thursday or Friday better? So if we could just roll this to Friday before we issue a KPS, I'd like to give him an opportunity to appear because he was willing to take the state's credit time served offer.
Okay. Very good.
Give him the benefit of the doubt.
Okay. You guys, I don't know, you guys are getting to be softies over there. I don't know.
Judge, will we put that on the morning or the afternoon?
It'll be in the morning. So we'll start at 9 o'clock. 7-1. You'll just remind me of that on that. Now, we've got three other ones listed this afternoon.
Yes, Your Honor, on the 2 o'clock docket.
Correct.
Yeah. I have Mr. Shannon Beck out here in the audience.
Okay, Mr. Beck,
Already
come
on
on
him.
up.
Casey Etheridge for Shannon Beck, and we're here in 2021 CF 20000.
Leah listed on behalf of Sarah Berkman.
And Mr. Beck would like to admit to the allegations in the affidavit and accept the state's offer to adjudication of guilt, reinstate probation, curfew for 90 days from 7 a.m. to 7 p.m., $100 cost of prosecution, $150 public defender fees, reinstate the suspended sentence of 36 months in state prison, and then the curfew may be adjusted as appropriate by probation. And the score sheet is going to be entered later by Ms. Bergman.
Ms. Bergman already signed, but it may already be submitted, but she was going to submit it when she got to the office.
You may, thank you.
And it is a downward departure based on a legitimate, uncoerced plea bargain.
Mr. Beck, would you raise your right hand?
Yes, sir.
You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God.
Yes, sir.
You heard what the state just said, you know what downward departure means?
No, sir, I don't.
Usually you can put your hand down. But that means you got a range. The court's given a range of sentencing. This is not a sentencing today because you all are agreeing to this.
Right.
But if there was an adjudication sentencing, the court gives a range. There's a floor and then there's a max, right? This is below the floor.
Yes, sir.
In order to do that, they got to get special permission from the court to downwardly depart, because the legislature says this is the range. Okay, it's another way of saying they're cutting you a break,
Yes, sir.
okay? I want you to understand it. You know, I don't understand all the dynamics because I'm not involved with it. I just want to make sure that you understand what you're doing. You obviously are getting a good deal here.
Yes, sir.
But main thing, I want to make sure you understand, you know, that your legal rights have been protected. You understand, you signed your plea and sentencing agreement.
Yes,
You've been
sir.
able to get all your questions answered from your attorney.
Yes, sir.
You understand you're waiving the right to a trial. You've heard me, I've said it 100 times today.
Yes,
You heard
sir.
You could give my speech for me today. You understand all that?
Yes, sir.
You feel like you have a legal understanding, you know what you're doing here today?
Yes, sir.
Okay. Any questions to your counsel or the court?
No, sir.
Okay, based upon that, the court will accept your plea, adjudication of guilt on the single charge, reinstate probation. There's additional issues, or not an issue, but ordering of curfew for 90 days, some costs and fees. It will reinstate the suspended sentence of 36 months. So that one's hanging over your head.
Yes, sir.
So you have every incentive
Yes, sir.
to be straight on this, so
Oh, I
please,
plan on
please
doing it.
follow through.
Oh, yes, sir.
Okay, and your curfew may be able to be adjusted, like if you're working at night or something. That just reiterates that you need to be in close contact with the probation so that they're tracking. If you're varying from something, make sure it's approved, et cetera, okay?
Yes, sir.
Very good. Thank you,
Yes, sir.
sir. Good luck.
Yes, sir. You have a nice day. Oh,
Okay.
Yeah.
And then we have Jonathan Gates.
Jonathan Gates.
Casey Etheridge for Jonathan Gates. We're here in 2020 CF 983. Mr. Gates would like to admit to the allegations in the affidavit and accept the state's offer of adjudication of guilt, revoke and terminate probation, 180 days in county jail with credit for all time served, $100 cost of prosecution, $150 public defender fees, all fees, fines, and court costs reduced to judgment. May I approach, Your Honor?
Stated in agreement.
Yes, Your Honor.
Mr. Gates, would you raise your right hand, sir? Do you swear or affirm? Thank you. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement. Is that what you're agreeing to? Yes. The core, obviously, is the revoking and terminating probation, so end the probation, but you'll have 180 days in the county jail, credit for time served. That's the core, plus some fees and costs. That's your understanding? Do you understand that's what this agreement is?
Yes, sir.
If you had an idea or an opportunity to ask any legal questions about this plea with your attorney, to make sure you got everything, you kind of understand what's going on,
Yes, sir.
okay? Because by doing this, you're waiving some legal right to a trial, right to contest this thing. You believe this is in your best interest?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea. There'll be an adjudication of guilt on the single count, revoke and terminate probation, sentence you to 180 days in the county jail. You will get credit for all time served. In addition, there'll be fees and costs that'll be reduced to judgment. Okay, good luck. Is the defense in agreement on the score sheet?
Yes, Your Honor.
Last but not least, Holmes.
Casey Etheridge for Marion Holmes, and we're here in 2019 CF 1823. Mr. Holmes would like to admit to the allegations in the affidavit and accept the state's offer of adjudication of guilt, revoke and terminate probation, 11 months, 29 days in county jail with credit for all time served, $100 cost of prosecution, $150 public defender fees, all fees, fines, and court costs reduced to judgment.
Would be a downward departure based on a legitimate, uncoerced plea.
And the state's in agreement.
Yes, Your Honor.
please, would you raise your right hand? So do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. You heard your attorney state the terms of your plea agreement.
Yes, sir.
Is that what you're agreeing to here today? I mean,
Yes, sir.
that's also contained in the plea and sentencing agreement that you just signed.
Yes, sir.
Have you gone over this agreement with your attorney? Make sure you got all your legal questions answered?
Yes, sir.
You understand what's going on?
Yes, I understand.
You
what's going on.
understand that by entering this, you're waiving the right to go to a trial. We actually had an evidentiary hearing scheduled. You're waiving that right. This is a final adjudication.
Right, yes.
Clear, you clear about that?
Yes, sir.
Okay. Do you have any other legal questions for your attorney or for the court for that matter? You're good?
Yes, sir, I'm good.
Okay. You believe this is in your best interest to enter into this plea? Is this in your best interest? You think this
Yes,
is
sir.
better for
Yes,
you?
sir.
Best for you?
Yes, sir.
Okay. Just asking. So court will adjudicate the defendant guilty on the single charge of the petty theft, revoke and terminate probation, so no more probation on this charge. You will get 1129 in the county jail, credit for time served, okay? There'll be some costs and fees. All those fees and costs will be reduced to a judgment, okay? Is that your understanding of everything?
Yes, I
Questions?
understand. No questions.
Very good. Thank you, sir. Good luck. I was wondering why we had such a long week, and I realized because the 4th is next week, and we had to move a couple of the,
Docket day would have usually been
if
on
any,
Monday.
if Eileen ever, if the clerk or anybody ever suggests to do this again, tell them no.
Yes.
It's been a very long week. We got one more day tomorrow, obviously. I think tomorrow a pretty good chance we can finish up by noon, but appreciate everybody's hard work.
Can we approach briefly, Judge? There's this.